Good day, everybody. Hello, and welcome to our Zoom CLE. My name is Gary Berger. I'm a board member of Legal Services of Eastern Missouri. And welcome to our third annual Estate Planning CLE sponsored by Legal Services. We're very excited to have you all. We're going to have about 200 people. I'm hearing some feedback. So if I mute you, please do not take it personally. And if you find yourself hearing feedback and stuff, please mute yourself. Please mute yourself. So we're going to start right away. Y'all have our schedule. We really appreciate all the support that the speakers are giving here to Legal Services and that you are today giving to Legal Services. You know, this is a national audience. There are legal service corporations throughout the United States. We suggest a donation to Legal Services for this CLE, and we appreciate that. We certainly appreciate that. We also would remind folks that as you're serving your clients, if you could please consider and remember Legal Services or your local legal services or legal aid organization in your estate planning and the legacy type of giving that you can provide to your lawyer clients, and we appreciate that. And no one else wants to hear from me anymore. So sorry, I'm doing multiple things here. I'm admitting other people and muting them. I'd like to get right down to it and get right down to the meat and potatoes of our CLE today. We have a great panel of speakers, top of their field in all of the answers, in all of their fields. And we're going to start with our first and featured speaker, Steve Gorin. Steve is a wonderful lawyer. He's a friend. You all know him from his amazing reputation in his area. I promised him I'd give him a short introduction. One of the things that I and some of my clients like and enjoy is his quarterly business succession solutions newsletters. I have the last one. And then one other housekeeping matter, and I'm going to put that in the chat. One other housekeeping matter. In order to not interrupt our great speakers today, if you would put your questions in chat, now you can unmute and ask them too. You all know, some of you guys know these speakers personally, and you may have good points, so you can do it. But we don't want to have that can be really cacophonous or really crazy on a Zoom. So I'm going to help monitor the Zoom and get the questions to the speakers. Without further ado, Steve Gorin. Steve. And this is how I'd like to prepare all of there you go. Thank you, Steve.
Thank you, Gary. Really appreciate it. Delighted to be helping out Legal Services and all of the community by doing this. So today we're going to talk about trust modifications, and I'm not going to go through all of my slides in detail, but there's been an important development that I'm going to touch from 2023 Chief Counsel advice that kind of threw out the gauntlet on the IRS attacking trust modifications. So this has become more timely. First, a little housekeeping. The slides, which hopefully you have a link to my most recent newsletter, which is free, and you can download a PDF that has supporting materials for this. On slide 3 is just how you can navigate between the slides and that PDF. PDF is 30 megabytes. It's about 4,000 pages or so. So you don't want to do this right now, but if you want to go back to review the materials later on, you can have the slides in front of you and the PDF in front of you, and here's how you can go and find the things. So you can see here on this slide 4, at the very top on the right, it's reference to 3B1B Romanet 2. So that is materials from the slides. From the big PDF. So So you have all kinds of technical materials to support what we're saying. So on slide 4 is just basically a list of some of the discussions which are primarily income tax driven. When you do a trust modification, you have really 2 issues. So one of them is if you're changing a beneficial interest, is there some kind of exchange taking place? Is a beneficiary trading a beneficial interest for either different beneficial interest or maybe cash or something like that? So do they have some kind of income tax exchange going on? And then the other question is whether that has gift tax consequences. Now, most of the more well-developed law relates to the income tax aspects, but there's also some estate tax. It's just not as well developed. I'm going to kind of go through what's on slide 4. I'm going to kind of go through those pretty quickly because again, it's more income tax. I'm just going to hit some highlights from them. So in terms of a trust division, again, is a beneficiary doing something to dispose of their interest in the trust? And if you think of a trust, you have the trustee who just has legal title, and the beneficiaries have equitable ownership. And so how do you really measure that equitable ownership? It's really kind of equitable ownership by more than one person, because you have the people who might currently receive distributions, and then you have the remaindermen, the people who take after the primary beneficiary dies. And so you have all these different people have interest in trusts. So if you're rearranging interest in trust, is there some kind of a taxable event from that? Well, if you have jointly owned property and you partition it, that's not a disposition. And also the trustee can make non-pro rata distributions and authorize particular assets in proportionate or disproportionate shares. That's an important provision to have in your trust, because that is really kind of where we're saying, look, each beneficiary does not have an interest in any particular property. The trustee can pick and choose among that and make distributions from that, which we call pick and choose fractional. And so it's important to have that in your trust agreement. Now, I have that directly in my trust agreements, and most lawyers do, but state law also has it. The Uniform Trust Code, which has been adopted by some 36 states, has it. Missouri certainly included this. It's in the litany of specific powers that are given to trustees. And so pretty much any trust you're going to encounter is either going to have that read into it by state law, or it's going to be in the trust agreement. Now, when you do a trust division, we have some regulations that go over this. I'm going to go into some of the philosophy behind this a little bit later. But trust divisions generally are not going to be taxable, income taxable events, and generally not estate tax or gift taxable events either. Mergers, those also are generally, those are not going to be income tax events, and usually not estate or gift tax events. And I have a letter ruling that is cited here where basically all the tax attributes from the original trust got preserved, so you didn't lose any of the tax benefits of the merging trusts, and everything just kind of got amalgamated and combined, but there was no particular consequence to doing that. Now, decanting is an idea of a trustee distributing assets from one trust to another. Basically, the trustee is using the trustee's power to make distributions. And if you can make distributions outright or in trust, well, then you could just make distributions in further trust. So that's a way to modify a trust. And the Uniform Trust Decanting Act authorizes amending the trust without transferring assets. And so you can just do modification so you don't go have to retitle all your assets. And Missouri did adopt that rule from the Uniform Trust Accounting Act. The people who drafted it for Missouri decided to just pick and choose stuff from the Uniform Trust Accounting Act and work it into our existing statute. That's RSMO 456.4-419. And so you can kind of look in there for all these rules on how to decant. The IRS, we don't really see much record of the IRS having decanted, like argued in tax court about whether decanting was valid or not. There was a case called Horvitz where you don't have a tax court formal opinion that you can cite as precedent, but there was some evidence. There's some motions like motion for summary judgment, stuff like that going on there, and the tax court basically said to the IRS, hey, you don't like the effect of the decanting, and you want to say that the taxpayer can't have that effect of the decanting, but you didn't show anything where you said, well, why was the decanting invalid? Because they appear to follow all the procedures. Why was it invalid? And when the judge asked that question, the IRS quickly conceded to the taxpayer within a couple of weeks. So I've got details from that case in these decanting materials. So this decanting, again, I tend to just use it to modify a trust without doing it. You can divide a trust. You can merge from an old trust to a new trust. So there's different ways to do decanting. One big issue, though, is Internal Revenue Code Section 2702 says that if a beneficial interest is transferred and the beneficiary, retains rights in the new trust, you don't just look at the difference between the rights before and after. You have to look at what the beneficiary's rights are in the new trust, and those have to be certain qualified rights to count. So most of you have heard of things like a GRAT, Grantor Retained Annuity Trust, or a QPERT, Qualified Personal Residence Trust. So those types of items, those are the only things that count for a retained interest. So if the decanting is considered to be a transfer of a beneficial interest followed by a retention, it could be that the beneficiary is considered to have given away all of their interest. So, for example, if you have an income interest in the first trust and an income interest in the second trust, an income interest is not qualified under 2702, so you would disregard that income interest in the new trust. So you would say that the beneficiary has given away their entire income interest, even though they actually have not. The Internal Revenue Code requires you to treat it as if they had. So we don't really know when you do the decanting whether that's considered to be a transfer of the beneficiary's entire beneficial interest. That's just totally unsettled law. Now, the argument that we will make that you'll see when I discuss this a little bit more is what we want to say is that the beneficiary's interest before the decanting or the modification was not really worth anything. So if they give away their whole interest, it's not worth much. So that's the argument we want to make generally with that. Okay, trust commutations. If you sell your interest in a trust, then you have a gain on that. It is generally going to be a long-term capital gain, but there's no basis that gets applied when you sell your life estate in a trust. Now, that's a general idea. There are a lot of exceptions to that, a lot of details to that rule, and there are ways you can be able to use the basis, but you have to do really specific planning. And you can see here at the bottom of slide 11, there's a link to a webinar that I did that goes through these issues. So that's free. You can just go ahead and click on the link later on at sometime after we're done with this webinar and view that and get the details. There's a great article that Ed Morrow, who's a lawyer in Ohio, went through and criticized a particular letter ruling on trust modifications, and that he goes through a lot of detail on that. So it's a great reading. I don't necessarily agree with every single thing he says, but he does a great job of analyzing the issues. And then you can see what I say after that, because I have right after the article that he wrote that he allowed me to republish. I then go into this idea of a commutation versus a mere division. So we have two different regulations. We have one regulation that says that generally, if the trustee is going to divide the trust, and that could be kind of picking and choosing, parsing things out, you're not going to have any consequences to that, and that can be really read broadly to maybe particularly protect a trust modification from an income tax consequence. On the other hand, we have a regulation in the commutation area that says, for example, if you have an income interest in a trust, a mandatory income, so the trustee shall distribute the income annually, and you give up that income interest, that's a very measurable thing. You definitely have a sale of that income interest. There's no doubt about that in the law. And then how do you reconcile the idea behind, well, if the trustee is going to be taking these actions, in some ways it's just making authorized distributions. In other ways, you might say, well, it's the person had a defined interest, so they get taxed from an income tax viewpoint on having done this transaction. And we have a regulation that says basically that you can't just pick what you like and disregard what you don't like. In fact, you have to assume that income taxation is going to apply unless you can make a really strong showing that the income tax exclusion is a much stronger argument than the argument for taxing it. So ultimately, you need to see whether the beneficial interest is like an entitlement that you can compare to measurable expectation of financial benefits. So again, I said if you have income interest, that's pretty definable. We have regulations that tell you exactly how to define that, how to measure that. And we also have software that lets us do that too. We have Tiger tables, which my partner Larry Katzenstein authored, and we also have Number Cruncher, which is published by the people from Lineberg Information Services, or whatever they call themselves now. And you can measure those. Just plug that into the software, it'll do a great job. A unit trust, an example of unit trust would be the trustee shall distribute annually 5% of whatever the trust assets are worth. You might say at the beginning of the year. Missouri's default statute for unit trust will have a 3-year weighted average. But that's, saying you get a 5% distribution every year, that's something you can measure. An annuity might be a fixed dollar amount that you get every year, so you can certainly measure that amount. So those can all be measured. So if a beneficiary is giving those up, then that's really going to be a sale. There's going to be an income tax consequence, and likely going to be a gift tax consequence as well. Assessable standards tend to constitute something that's measurable. So if distributions could be made for health, education, maintenance, and support, then the beneficiary can go and argue to the trustee, make a case, please give me a distribution. And the beneficiary can argue abuse of discretion there. And then they can sue and get something. All right, so the question is, can you measure the beneficial interest? That's kind of the ultimate bottom line. And my materials do go into some details as to various resources you can use to figure out how you would measure a beneficial interest. Now, when is a change of an expected series of distributions material? Again, there's no clear law on it. There is some clear law on debt modifications, and if you think debt is a series of payments, so we know that the debt is clearly measurable. So if something is not a modification of a debt and not taxable, then presumably it wouldn't be a modification of a beneficial interest either, because that's not as strong an interest as debt would be. And so let's go on. So the idea is, if the beneficiary does not have well-defined rights, it's difficult to say the beneficiary has exchanged something of value. So if the trustee has absolute discretion whether or not to make distributions to beneficiaries, and that's the only standard in the trust, then the beneficiary really has no rights at all. I mean, abuse of discretion can't even be measured. You'd have to really show some horrible misconduct by the trustee. That's really nothing that the beneficiary can really successfully sue on. Again, absent some really egregious misconduct. Now, what if you have a trust that says, okay, the trustee can make distributions to my spouse and descendants, and then when my spouse dies, it goes to the descendants. Okay, it's, you know, to my kids outright, or whatever, or in trust, or whatever you might want to do. So then suppose that they decide to split apart the trust. Like, for example, maybe it was a second marriage, and the kids and the surviving spouse are arguing with each other. Well, if the kids and the spouse are kind of bargaining with each other and coming up with kind of, you know, where they're equivalently selling their interest, well, then you'd have some kind of taxable event, income taxable, and perhaps gift taxable as well. But if the trustee has absolute discretion to distribute currently to the primary beneficiary and to the remaindermen. So in my example, trust for spouse and descendants, remainder to descendants, the descendants are current beneficiaries. And the trustee has absolute discretion to distribute to any of them or all of them. Who's to say that the spouse is selling her interest, or that any beneficiary is selling their interest? The trustee can simply make the distribution, and voila, it's done. So that then would be simply exercising the trustee's authority. There's no sale going on, no gift going on. Beneficiaries really can't object very strongly because it's absolute discretion. So this is why it's really helpful to have in trusts the ability for the trustee to distribute for the absolute discretion. Now, of course, you have to be careful who your trustee is and their relationship to other parties. So, you know, I don't want to put up, say you have to give it like a license to steal to anybody, but the idea is, if you have a purely discretionary trust, then you can do more modifications. So those who might be interested, if you have a financial institution managing the assets, and you just appoint them as a corporate trustee and give them absolute discretion, then that gives a lot of flexibility.
Thing right in the middle, Gene.
Okay, GMS needs to be muted. There we go. All right. So the idea here is to have this flexible drafting. By the way, my idea with the corporate trustee is the primary beneficiary can remove and replace the corporate trustee. So if the corporate trustee is doing things that the primary beneficiary doesn't like, they can put in a new one. I'm not advocating this as a panacea. Very few of my clients actually have corporate trustees being the sole trustee or even a co-trustee. But it can work well. It's always an option to consider. And certainly for special needs trusts, it's also a potential idea. So sometimes I'll do ascertainable a lot of times I'll do ascertainable standards, and I will have absolute discretion in there as well. All right, now let's get to the heart of this IRS chief counsel advice that raised a big stink in the estate planning community. So in this case, there was an irrevocable grantor trust. So an irrevocable grantor trust, the two components, irrevocable, means, of course, the grantor cannot unilaterally amend the trust. And generally those are structured to be outside the estate tax system. A grantor trust is where for income tax purposes, the trust is disregarded and the grantor is treated as the owner of the trust. This is very common if you have a trust for spouse and descendants and the grantor is still alive. That is pretty much automatically a grantor trust, and the grantor can't get out of that. But you can also do irrevocable trust for the kids, for example, and set it up so it's not necessarily going to be a grantor trust, but then you can give certain powers. The most common one is what we call a swap power, a power to substitute assets of equivalent value. And if the grantor has a swap power, then the grantor is taxed on the trust. And very wealthy clients, it's a nice way to deplete their estate. You set up this irrevocable grantor trust. They pay the taxes on the trust income. Their payment of the taxes on the trust income is not considered to be a gift. We have clear authority on that, Revenue Rule 2004-64. Again, this is all in the material, so don't worry about writing it down. And so it's a way to let the trust grow estate tax-free while depleting the grantor's estate while they pay these taxes. Now, of course, anything that's done can be overdone, and you can have a time when somebody has a grantor trust and then maybe they have a business in it and the business gets sold for much more money than it was originally worth, and the grantor may have problems paying the tax on that and may want to have a distribution or may need a distribution. Now, in Missouri, you can draft a trust that says that you have the beneficiaries, whoever they are, and then the grantor is also a discretionary beneficiary. And if you don't, if you make that be absolute discretion and not ascertainable standards, but absolute discretion for the grantor, and the grantor never receives any distributions, that's not going to cause estate inclusion. That Illinois does not have that rule. It's only Missouri and a handful of other states that have that rule. Now, in this particular case, in this chief counsel advice, we had an irrevocable grantor trust, and the grantor wanted to get paid their income taxes, and there was no provision in the trust to allow that, and so they modified the trust, and the beneficiaries consented to the modification. And now let's go back to some real fundamentals of gift tax. If somebody affirmatively consents to the trustee doing something, and that causes that person to have less of a beneficial interest, they are making a gift. Again, how do you measure that gift? I mentioned earlier, it could be either a gift of the entire beneficial interest or a gift of part of the beneficial interest. But if they're consenting to money leaving the trust, and then that reduces the amount of money that the beneficiary is going to get, I mean, that's definitely a gift. Now, what if they don't object? So if the trustee causes money to leave the trust and the beneficiary doesn't object, then the beneficiary could always sue the trustee and say, hey, you made this distribution to somebody else. You should have saved the money for me. I'm going to sue you for that. So until the statute of limitations for that suit expires, the beneficiary hasn't made a gift yet, because the beneficiary can always try to go recover the money. But once the statute of limitations expires, the beneficiary has made a gift. That's the argument. So that's the argument that the CCA was making. And now, I mean, you can imagine there's all kinds of things a trustee can do. Beneficiaries might not think it's worthwhile to enforce their rights, because the beneficiary might just think it would be too expensive to try to enforce their rights. But we'll get into that argument in a moment. But you can see here the CCA cited this regulation that says we don't care whether the beneficiary wanted to make, whether the donor wanted to make a gift or not. The question is not what your motivations were subjectively, but what the objective facts were, the facts and circumstances. So now, in this case, we don't know what kind of grantor trust that trust was. Is it the kind where the spouse is a beneficiary, where you can't turn off grantor trust status? Or is it one where the kids were the beneficiaries and there was a way to turn it off? We don't know that. And it does not address whether the grantor, so if the grantor can turn off the grantor trust status, it's clear that that's not a gift. The grantor's failure to turn off the grantor trust powers, in other words, the grantor could always turn off in some trusts, the grantor could turn off the grantor trust powers and then wouldn't have to pay the tax. And the fact that they're still continuing to pay the tax and they're not turning off the grantor trust status, that is not a gift. And the CCA did not address whether might have been some back and forth going on. The grantor can say to the trustee, hey, just in case some really big event happens, I would like you to be authorized to make a distribution to pay my taxes. And the trustee would say, no, that's having money leave the trust. The beneficiaries would sue me for doing that. And then the grantor would say, well, here's the deal. If you don't do this, I'm going to turn off my grantor trust powers. And then you're going to be stuck with that tax. The trust, is that going to be the beneficiary's best interest for the trust to pay the tax every year? Or are you better off with me just leaving it alone? I'll keep paying the taxes. But if there's something that happens that really sets me back, that you'll make me whole on that. So I would say in pretty much just about every case, the beneficiaries are better off with agreeing to let the reimbursement occur, rather than having the trust pay the taxes. After all,
Steve Gary, you're doing great. Hey, Steve, is that your usual advice to them? Not to interrupt your flow here, but is that your usual advice?
To what?
To keeping that back so that beneficiaries don't have that tax obligation?
Oh, my usual advice is to keep the grantor trust status turned on so we can deplete the grantor's estate to get them below a taxable estate. At the same time, that is tempered by the idea that we don't want to bankrupt the grantor. And I've had some grantors who say, hey, it's impossible to maintain a decent standard of living with less than $20 million. Now, that would not apply to 99% of us on the call, but there are clients who say that. And they would rather have estate tax paid at their death than deplete their assets below whatever level that is. So I generally do advise people to keep their grantor trust status on, but they will, they have to see. I mean, the grantors do not pay estate tax, okay? Their kids pay the estate tax. Their kids who did nothing to deserve this money pay the estate tax, okay? So the grantor is entitled to live their life however they want. Yes, I want to help save estate tax, but it's not the be all and end all. I just want to present the tools for saving estate tax, and then you have a discussion with your clients about whether the estate tax savings are worthwhile or whether that's going to compromise their own retirement objectives and therefore is not a worthwhile thing to do.
Thank you. Thank you, Steve. Sorry to throw that in there.
No problem.
Please continue.
Okay, so now let's kind of take a step back here. So, we don't know what kind of bargaining can go on for some trust regarding this grantor trust being turned off or not. We're not necessarily really going to care about all of trust modifications being irrevocable grantor trust. There's a lot of reasons to modify trust because changes of family circumstances, an outlaw, meaning you have a daughter-in-law or son-in-law who is no longer favored, maybe money grabbing. I mean, there's all kinds of reasons to try to modify a trust. So I don't want to obsess too much on this grantor trust thing. I just wanted to provide the context for that CCA. Now, what if a trustee is a beneficiary of a trust and the trustee makes a distribution to another beneficiary? If you take the CCA to its extreme, arguably, the trustee as a beneficiary would need to bring a claim to sue himself or herself for letting the money leave the trust and go to somebody else. So you have child and grandchildren who are beneficiaries. Child is the trustee. Child makes a distribution to the grandkids. The CCA, taken to an extreme, one might argue that when the child makes a distribution to the grandkids, the child as a beneficiary should be maybe making a gift by letting that money leave the trust and being spent for the grandkids instead of being spent by that child. And then you'd have kind of the silly thing of the child having a duty to sue himself or herself as trustee. But if you take the CCA to an extreme, by not objecting to the distribution to the grandkids, that child who's the trustee has made a gift. Now, that actually is not what the CCA should be interpreted as, because let's look at this other gift tax regulation that it's just a subsection. It's just a paragraph within the same subsection that the CCA cited for saying that there was a gift. It says, if the trustee had a beneficial interest in the property, then having that money leave the trust and go to the grandkids is not a taxable transfer if it's an ascertainable standard. So the idea here is, if you have the trustee may distribute for the child and grandchildren's health, education, maintenance, and support, and the trustee makes a distribution to the grandchild, well, again, as an ascertainable standard, that's something that the grandchildren could enforce. So the trustee is merely as merely exercising fiduciary duties that are clearly authorized within the trust, and in fact could be enforced by the other beneficiaries. In that particular case, the regulations say the child who is the beneficiary does not have a duty to sue himself or herself as trustee for letting that money leave the trust and go to the grandkids. So the trustee beneficiary does not have a duty to fight against distributions to other beneficiaries. There's no absolute duty to do that. It's tempered. If what the trustee is doing is within what the trustee needs to be doing, or clearly authorized, then it's not a gift. So we have a continuum. Does the beneficiary have rights that they could enforce against the trustee? What's the possibility of winning that lawsuit? Who knows what that is? So getting back to my theme from before, the more you can attenuate the beneficiary's rights, make them not as enforceable, then you don't have these gift tax issues going up. Now, I have like 2 more minutes before I want to wrap up and see what other questions there are before we do more. And one of the issues is, okay, how do we measure the gift that was being made? I already mentioned that it might be a gift of the entire beneficial interest. And what if that gift is hard to measure? Well, there's no excuse for not measuring it. You have to measure it and put something down on the gift tax return, is what the tax court has said. And in this particular case, there was not a gift, but just the fact that it's a complicated issue to measure it, that's not an excuse. If you made a gift, then you made a gift. And so the whole point here is, how much of a gift is it? The CCA did not measure the gift. They just said you've made a gift. And if the beneficiary was not receiving any distributions at all throughout the year, then it's like throughout all the years. So you have a trust that's been administered for the last 10 years. Beneficiaries never received a distribution. In fact, you don't think the beneficiary will ever receive a distribution. And that's what we do with a lot of these estate planning trusts. The goal is to accumulate the money inside the trust. So when you have these trusts for the spouse and descendants, they're irrevocable. The idea is to accumulate those. And so you're often not going to be making any distributions to anybody. You just want to accumulate those and save estate tax. And then the grantor pays the income tax bill. So these are growing and growing without being burned by income tax. It's a sweet deal. So if distributions have not been and never expected to be made to that beneficiary, then you can argue, yeah, maybe the beneficiary made a gift, but the gift was 0. And we have some a letter ruling here. You can see the last sentence that you may have a nominal interest. IRS concedes you might have a gift that's worth almost 0. Okay, so trust modifications. I kind of go through some issues here. I go through the idea.
Hey, Steve, let me just interrupt for a minute, if you don't mind. Hey, if you have questions for Steve, it looks to me like he's going to go through some more of his slides not to read your mind, Steve, but to pick up any other points. And so if you have questions for Steve as we're going through, stick them in the group chat. Go ahead, Steve. Sorry to interrupt, sir.
No problem. Thanks, Gary.
No worries.
So the question is, if you want to set, if you leave this claim against, like if the trustee does something and the beneficiary has a claim, if you leave that claim outstanding for decades, that claim can grow and grow and grow in the value. So the idea is to cut off claims. And so I'm a big proponent of having the trustee cut off the claims by providing a notice on a roughly annual basis that describes, that basically goes on what's in the trust. And I do have a sample notice in my materials. It's not it's not in this particular 3B 1B Romanet 2, but there is a cross-reference to it in there. Oh, here it is, slide 32. You can see my notice, 2J4J. So there's a sample notice that you might consider modeling years after. You of course are liable for whatever you do. So I'm just providing ideas for you, and you can implement them as you wish. Okay. Retroactivity. When you make your trust modification, usually it's going to be prospective. IRS rarely recognizes retroactive modifications. And of course, I mentioned that how you will identify the beneficiary's beneficial interest. Okay, so again, we don't know if the IRS is going to be able to take the position that the entire beneficiary's interest was a gift, even though the beneficiary retained an income interest, because 2702 might say we disregard that retained interest. So I have there's some issues regarding generation skipping transfer tax. I'm not going to go into those details. If you do a decanting, which again could be just a trust modification, if you do a decanting that results in a change in beneficial interest, the IRS will not issue a private letter ruling on whether or not that is whether that does have any of the consequences described on 39. And the IRS also applies this to trust modification. So we're not going to get anything from the IRS to really provide any comfort here. So I know Gary already put in my chat. Oh, here we go. You've got both of these. Gary put in the chat on how to get my newsletter, which is totally free. So I don't get anything out of it other than the fact that it's nice to be in contact with all of you. So Gary, any other questions or comments? Anything you might want me to elaborate on anymore?
I don't. I had one, and I don't see any. And if anybody has something smarter to ask than I do, but I guess the one question I had, Steve, is with this CCA 202-23-5, this letter you've been talking about. Are you modifying trusts? Are you coaching grantors differently? Are you practically? I get you. I get the detail here, but what are a few takeaways about the practical things you're doing now with this?
Well, absolutely, I'm modifying trusts, and that's because clients have a demand for doing that. The question is, what kind of precautions do you take to avoid the modification having tax consequences? You know,
exactly. And are you counseling clients of the potential for these? And is it murky enough that you don't know if that's realized? Is that a challenge?
I will counsel them that there is potential for it. I try to do things to minimize it. Again, the biggest argument I make is a lot of these trusts, we have beneficial interests that are worth nothing, and so then I'll report that as a zero taxable gift. The other thing I will sometimes do is to make sure that the trust modification, maybe it's administrative in nature and it doesn't take away. Sometimes it's a modification of a power of appointment, and the power of appointment already could take money away from the beneficiary. So we'll argue that that's not a taxable gift by the beneficiary by not objecting. But another thing I do for the trustees is, of course, they can always get sued by a modification. So I will do a little two-step with my modifications. Is I will have the trustee provide the 1 year notice that I have here on slide 31. I will do the 1 year notice, and you know, a little bit of overkill with it, but again, you can see how I do my notices. But I do the 1 year notice, and I also have the trustee reserve the right to undo the modification if a beneficiary objects within that 1 year. So the idea here is I don't want to have the beneficiary's consent because the gift tax law does differentiate between a beneficiary consenting and failing to object. Now, the CCA argued that a failure to object is also a gift, but it didn't explicate on how that's a gift, under what circumstances the failure to object a gift or not. And I already went through a regulation that says in some circumstances it absolutely failure to object absolutely is not a gift. So I do want to have a failure to object rather than a consent. So the way I do my failure to object is I do the 1 year notice. I give the trustee the right to undo the modification if a beneficiary objects within the 1 year. So the idea is that they're not getting a release, but if a beneficiary objects, they can undo it and they don't have liability because they're undoing it. So then if the 1 year passes, they don't have liability because the beneficiary can't sue them. So that is when I do the modification, I don't want to do a consent. I want to do the failure to object. You can also go to court to get a court order and then have the beneficiaries not object in court. So that's another way to do that. But you don't want to have a consent, an affirmative consent by them. And you don't want to have them consent to the court order either. You just have a little hearing with the judge and the beneficiaries don't raise the objection and then you're done.
Thank you. That's a good practice. That's a good practice. Steve, I think we're done. Thank you for your great presentation. Just as a reminder, you said it, I said it, but the materials and the different modifications that you outlined through many, many slides and different things are all in the materials. I put the link in the chat. Why don't we go ahead? So thanks a lot, Steve. Really appreciate this and your leadership on this for legal services. Thank you. What we're going to do, folks, is we're going to take a 4-minute break, and then we're going to come back with Jill, Lee, and John. So hold on. Let's take a short break before we keep going. Thank you.
Thank you, Gary.
All right, Steve, you think everybody's had a minute to move for a minute? I have, thank you. Folks, next we have a panel of three great lawyers. I'm going to because they're friends of Steve's, and Steve was able to coordinate this. Steve, I'd like to hand it over to you for the introduction, sir.
Thank you. Thank you, Gary. So Jill, Lee, and John are ACTEC fellows. They're members of ACTEC's business planning committee, and they actually went through this presentation at the ACTEC meeting just not even a week ago. Now we wound up spending about an hour and a half, more like an hour and 3/4 going through it, and so they've condensed this down to a mere 45 or 50 minutes. So and everybody at the business planning committee was very appreciative of it. You know, these topics of independent contractor and non-compete are key for business owners. And you know, even though this is an estate planning webinar, a lot of us do estate planning for business owners, and also a lot of you are business owners, and so you need to know what's going on. So the other thing I also want to mention is that we did have contributions from a member of the American College of Employee Benefits Council, who's credited on one of the slides too. So we really have a kind of an all-star panel here, and I'm gonna let them go ahead and do it. Go ahead.
Thank you, Steve. I'm going to be leading off, and I'm going to share my screen, and hopefully I can get this in presentation mode and share my screen at the same time. So.
Hey, Jill, your audio's coming in and out a lot. Could you be at the microphone? You're good. You're good. I'm just noticing something right away. Please continue.
Okay, perfect.
That's better. Thank you.
Okay, so you should see my screen, and let me know if you see it in presentation mode.
We're good.
And is it presentation mode?
Yes, ma'am.
Perfect. Okay. Thank you for allowing me to be here. I'm joining you from Cincinnati, Ohio, and it's fun to be able to do these things now that we can all be together but be far away at the same time. So I'd like to start out with, what has happened. The Fair Labor Standards Act, or FLSA, is a federal law that establishes minimum wage, overtime pay, and child labor standards. On March 11th, 2024, the Department of Labor published a final rule revising the DOL's guidance on what constitutes an independent contractor versus an employee. I'm joined by John Draneas, who should be online here, to describe the intersection of the FLSA, new 6-factor test, state and federal characterizations of an employee versus an independent contractor, and the ERISA characterization of employees versus independent contractors. Before getting to this discussion, let's look at what happens if an independent contractor is recharacterized as an employee. And this is our parade of horribles. Overtime. The FLSA requires that workers that are employees be paid the federal minimum wage, which is at least $7.25 an hour, plus they get overtime of not less than time and a half for all hours worked over 40. There are state minimum wage and overtime requirements. And John, if you're here, if you want to jump in.
Well, I'm here, but I think Gary has to turn on my camera.
Okay. Can you see my screen? And do you want to go over the state minimum wage and overtime?
Hey, John, I just did. It's great to see you, man. There you go. You're good now, and we can hear you. Thank you, sir.
Nice to be here live and in person. So you've got state law requirements that also mandatory break day, whatever might be on the menu in your particular state. So the real problem here is that the minimum wage enough overtime.
Hey, John, I'm losing your audio. I don't know if other folks are. Sorry about that. You're talking about minimum wage?
Yeah, if you've got to pay overtime.
Thank you. That's better. Thank you, John.
it's amazing what 2 inches on the microphone does. If you wind up having an employee that with an independent contractor and you have to pay time and a half, you don't have, normally the employer doesn't have the time record to be able to defend the employee's claim. So the employee makes a claim saying, I worked 50 hours every week for the last 3 years and you owe me all this money, and the employer can be kind of defenseless. And then there are state law requirements about how quickly you have to pay somebody. For example, in Oregon, if an employment relationship terminates, or if you terminate an employee, the final paycheck is due by the end of the next business day. And if you don't meet that deadline, then they're entitled to a penalty equal to the regular rate of compensation for up to 30 days or until you do pay that. So it can become expensive. Back to
Go
you.
ahead, Lee.
And then we also have the potential for class action lawsuits. In 2015, FedEx settled a lawsuit for $228 million after the Ninth Circuit found that FedEx mistakenly classified 2,300 truck drivers as independent contractors. Not a good day for FedEx. There's employer liability for federal payroll taxes, Social Security, and Medicare taxes. Employers are required to withhold and pay taxes on federal payroll, Social Security, and Medicare, as you all probably know. However, workers that are classified as independent contractors are responsible for paying their own payroll taxes, known as self-employment tax.
You have the, you have that defenseless cluster again. If you think that you're employing an independent contractor who turns out to be an employee, then the employer under federal and also under state law is required to pay all those withholding taxes that were not paid. Now, the employer is entitled to get a credit for taxes that were paid by the employer, but that's hard to get the dots connected. And a lot of times the independent contractors don't pay tax. But if you look at the math, it's not really that much different. The employer and the employee combined pay about the same rate that the independent contractor pays self-employment tax. So the financial incentive here is minimal. You avoid things like comp and unemployment, perhaps, if it's an independent contractor, but those are pretty minor. But the ability, so when it doesn't pay properly is pretty dramatic.
And there are penalties for failing to deposit payroll taxes. The failure to deposit penalty on a federal level ranges from 2 to 10% of the unpaid deposit with interest, depending on the lateness of the deposit. And that interest can get really, really high. There are back payments for missed benefits. Misclassified workers can file complaints with the Department of Labor or with their state to claim employee benefits that were missed out on during the period of misclassification. If these claims are validated, employers may be on the hook for back payments with regard to benefits normally afforded to employees, including 401k, healthcare, equity compensation, paid time off, family and medical leave. So an employer can mitigate these risks with plan language that denies the eligibility for any worker classified or treated by the employer as an independent contractor, even if later reclassified as an employee. So this is a piece that you can put in the plan to mitigate this reclassification risk from a benefit perspective. There are fines and penalties for misclassification. For employers subject to the ACA employer shared responsibility requirements, generally those employers with 50 or more full-time equivalents, failure to properly classify workers can result in penalties also. And on an immigration perspective, an employer of an employee is required to keep the I-9s. However, someone who hires an independent contractor is not required to keep I-9s. So reclassification can lead to potential issues in the event of reclassification of a worker from an independent contractor to an employee, as the employer may be missing these important I-9 documents authorizing these misclassified employees to work in the U.S. The employer will be required to complete and retain an I-9 with the conversion date as the start of employment. Because the employee must participate in the I-9 process and provide documentation evidencing status and ability to work legally, employers should allow ample time for this process to be completed. It can get really kind of difficult if there has been a reclassification from an independent contractor to an employee. And also on the employee level, the employee could be denied any trade or business deduction that they may have taken under the belief that they were an independent contractor, which can lead to unpaid tax liability, tax penalties, and interest for that worker.
Thinking about these rules as being intended to protect the employee, a lot of employees would really prefer to be contractors. In fact, a lot of times we insist on it because it allows them to be self-employed and take deductions for a lot of things that they might not be able to take income tax deductions for otherwise. So that reclassification is not necessarily a consequence at the employee level either.
Okay, John, are you ready to move, for me to move on for now?
Yeah, go on to the federal.
So the evolution of the economic reality test. In 1947, the Supreme Court case, U.S. v. Silk, the court employed an economic reality test to hold that coal uploaders were employees in determining whether these particular workers were independent contractors or employees within the meaning of the Social Security Act. The Supreme Court applied the same rules as had been applied to the National Labor Relations Board in the case Labor Board versus Hearst Publications. In Silk, the U.S. Supreme Court held and noted that the coal uploaders had no opportunity to gain or lose except from the work of their very own hands and these very simple picks and shovels that the workers provided. This economic reality test is basically the same as what has been used to effectuate the FLSA. So as I mentioned before, on March 11th, 2024, the FLSA developed a 6-factor test. This economic reality test also has been present in the IRS guidance. In 1996, the IRS released guidelines that emphasized a control-based inquiry where the facts and circumstances of a worker's situation were analyzed with the intent to determine the right to direct and control a worker. Today, the new economic reality test analyzes all the facts and circumstances of a worker situation to determine whether the worker is economically dependent on the employer. The FLSA 6-factor test is not an ABC test. So if you have 1 or 2 factors, that doesn't mean that you're necessarily an employee versus an independent contractor. It's really a factor-based inquiry, which takes into consideration the totality of the worker's circumstances. And this is the FLSA's 6-factor test. The first is the opportunity for profit or loss based on managerial skill. The DOL has put out FAQs for us, which you can find, and they're part of the package that you've received. And really, they're quite instructive. Included in what is the opportunity for profit or loss based on managerial skills are some things like, can the worker negotiate their pay? If they can, it looks like an independent contractor. Can they accept or decline jobs? Can they choose the order in which the work is performed? Can they hire others? The second factor is, what are the investments? Are there any investments by the worker? And what are the investments by the potential employer? Is the investment minor? And if it is, that indicates that it's an employee. The third is the degree of permanence of the work relationship. Is this work relationship continuous or exclusive? That they can't work for others? So that would indicate an employee. The fourth is the nature and degree of control. Can the worker set their schedule? Indicates an independent contractor. Who supervises the performance of the work? If it's the firm, it looks more like, or company, it looks more like the employer. Can the firm limit the ability to do work for others? If so, that looks like an employee relationship. The fifth factor is the extent to which the work performed is an integral part of the potential employer's business. Is the work critical or necessary, central to the potential employer's principal business? For example, in the FAQs, this example is given. A large farm grows tomatoes that it sells to distributors. The farm pays workers to pick the tomatoes during the harvest season. Because a necessary part of the tomato farm is picking the tomatoes, The tomato pickers for the FLSA are integral to the company's business, and that would indicate employee status. The last factor, the 6-factor test, is the skill and initiative. Does the worker use specialized skills, and do these skills contribute to a business like an initiative? This factor indicates the employee status if the worker does not use any specialized skills in performing the work, or where the worker is dependent on training from the potential employer to perform the work. It is not only the technical skills, but also the use of the skills in connection with a business-like initiative. For instance, a welder who markets specialized skills for multiple customers, that's an indication of an independent contractor. It should be noted that the FLSA and IRS can arrive at different conclusions as to what constitutes an employee versus an independent contractor. The DOL's FAQ specifically state that the IRS applies its own test based on a common law test, as opposed to the economic reality test used by the FLSA. And this is a look at the 20-factor test that came out in the 1987 revenue ruling. I'm not going to go through all of these, but these were the factors that the IRS described in 1987 as what it would look at when determining employee versus independent contractor. And they've migrated over to more of a economic or common law reality test. It's possible that a worker can file Form SS-8 to ask the IRS to determine whether it's a employee versus an independent contractor. So I'm gonna So there are basic 3 categories that the IRS now looks at in determining independent contractor versus independent employee relationship. And these relationships, 3 relationships that they look at, are clustered around behavioral control, financial control, and the relationship of the worker and the firm. So ERISA also employs its own common law test. It should be noted that in the case Nationwide versus Darden, the Supreme Court adopted a common law test for purposes of determining who qualifies as an employee. And they consider the 13 factors that are on your screen. As with other similar tests, all of the incidents of the relationship should be assessed and weighed in determining whether someone is an independent contractor or a employee. There are several commonalities between the FLSA 6-factor test, the IRS 20-factor test that it used in its 1987 Rev ruling, and the ERISA common law test. And these commonalities are the worker's opportunity for a realization of profits and losses, the worker's investment in facilities and equipment, a continuing or permanent relationship between the worker and the employer, integration of the worker's services to the activities of the company, and the nature and degree of control. These areas of overlap can be especially important to consider when analyzing whether to classify a worker as an employee or an independent contractor. Where do these tests diverge? This may have more to do with how the factors are weighed and interpreted rather than the factors themselves. The FLSA's definition of employment, suffer, or permit to work is recognized as potentially encompassing a broader group of workers than who might qualify as employees under the traditional agency or common law tests. An interpretation that favors finding employee status may be more appropriate when applying the FLSA test. Per the DOL, economic dependence rather than control is the ultimate inquiry for purposes of the FLSA. Is a worker as a matter of economic reality and business for themselves? Strictly speaking, how does the FLSA impact the status for tax and benefits purposes? Per se, they're independent considerations. A worker could be an employee for FLSA purposes, but not for the Internal Revenue Code or ERISA. However, as a practical matter, reclassification under the FLSA may prompt reclassification analysis for other purposes as well. Employers should proactively look to properly classify their workers for FLSA purposes, even though they may voluntarily choose to treat workers more as employees for other purposes.
So we go back to the state law slide because you've got differences between the IRS rules and the DOL rules. Also have state law differences to consider as well. So all these, look at all of these different approaches to the definition. They're all fairly similar, but
Hey,
they just-
John, John, I don't mean to rudely interrupt you. Could you please make sure you're working on that? And I apologize, and it may just be me. I'm a little hard of hearing. I'm a little old, but thank you, John. Thank you.
still volume problems.
You're good now. When you lean into it a little bit, it's a little bit better for me. Thank you.
Okay, happy to help. So the state law is a third dimension to this. All these different approaches are pretty simple, but they place this in different places, I think is really the difference. At the Oregon statute on the screen as an example. This is about 20 years ago. I was the chair of the taxation section. We tried Oregon law change to be the same as federal tax law. And this is what we started with. We had freedom from direction control and also, but there was no guideline to that. And we were trying to eliminate the independent established business requirement. And we wound up in a real political firefight. There was tremendous opposition from the union to this, and it led to a task force serving on that would have to try to come up with a compromise. So we came up with this on the next page. You could
The next page.
you have to remember, these things are all political. It's not like the agencies are sitting there trying to dream up these rules and definitions just on their own. They're getting a lot of pressure from interest groups all the time. In this case, in our case, it was the unions, in particular trade unions, because all of the construction contractors have been making independent contractors out of all of their employees. And the unions can't organize independent contractors. They wanted everybody to be an employee. So my approach here was to define independently established business, and we have 5 tests and some specifics about how one would meet that test. Now, if you look at this, it's very similar to the Department of Labor 6-factor test. Don't blame me for it. I didn't have anything to do with the Department of Labor rule. But identify all the different characteristics of an independent established business. And we came up with these 5. And these are the things that you would look at. Now, the difference in the DOL rule is that in the Department of Labor rule, there's no, it becomes subject. Things can make that factor go one way or the other. In the Oregon statute, if you establish those facts, you've met the factor, and it's a much easier thing to do. And some of the DOL rules are kind of questionable, like the degree of permanence of the relationship. Well, how are you supposed to know how permanent the relationship is when it starts? How long do you have to wait until you know whether it's a relationship or not? Is it years? Is it 2 years? Who knows? You know, if that factor is what's going to tip the scales, then it would probably convert an independent contractor to an employee. And the other one, the integral nature of the work. Well, today we have lots of companies that sell products manufactured. They contract out the entire production process to independent outfits. That's a normal way of doing business. You don't have to produce the product in order to be the manufacturer. Yet having an independent contractor do production work that's integral to your process would make everything look like you have an employment relationship.
Okay, so going back to here, what happens if there has been a reclassification? How can we avoid falling prey to the parade of horribles? And where can we receive some help? As I mentioned before, Form SS8 can be filed by a worker or an employee to ask the IRS for the classification of the worker status for purposes of employment taxes and income tax withholding. Basically, that form looks at 3 indicators: behavior control, financial control, relationship of the worker and the firm, and the indicators that cluster around those 3. But also, if you have had a misclassification, Section 530 of the Revenue Act of 1978 is a relief provision that terminates a taxpayer's employment tax liability with respect to an individual not treated as an employee, including misclassified workers. You can get Section 530 relief if the following 3 requirements are met: reporting consistency, the filing of all required federal tax returns on a basis consistent with the independent contractor classification; substantive consistency, the treatment has been consistent with the treatment of workers in substantially similar positions; and the employer had a reasonable basis for treating the worker as an independent contractor. If all of these 3 things are present, it's possible to get Section 530 relief. It's also important to note that Section 530 is not incorporated in the Internal Revenue Code. So compliance with the 530 requirements allows employers to escape the burden of demonstrating the appropriate status of their workers under either statutory provisions or common law rules. This means that the misclassification cases that would otherwise be limited to a factor-based inquiry now begins with attempts to obtain Section 530 relief. There are settlement programs under Section 530. A classification settlement program is an alternative to litigation, allows taxpayers and tax examiners to resolve worker classification cases as early as in the administrative process as possible. CSP agreements are binding on both the IRS and the taxpayer for all future tax periods. Also, there's a voluntary classification settlement program. It allows taxpayers to voluntarily reclassify their workers as employees for employment tax purposes for all future periods. Any employer who currently treats workers as independent contractors or other non-employees are eligible. Again, they must meet the requirements for the reporting consistency and substantive consistency prongs of the 530 test. And they cannot currently be under an employment tax audit or a DOL audit to enter the voluntary classification settlement program. If release is granted, there's no penalties or interest assessed, but the worker must pay 10% of the employment taxes that would have been paid for the most recently closed tax year. And at the end, I've just got some relevant code sections for you.
Thanks, Lee. And now, in your, can I ask you a question?
Sure.
So you know what I run against too is do you see your clients or employers thinking about liability issues too? I know short term you're thinking about overtime, trying to avoid overtime and that kind of stuff. But I encounter, I'm more of a personal injury lawyer. I see all the time where your clients need to know that if they're going to characterize someone as an independent contractor, they can explode their liability because they get out of work comp. They don't have work comp protections, and they can have these huge. I have a number of cases now where I have their independent contractors, and I get it, and then I get to have a civil case with jury instructions and no cap on recovery. And I sometimes think that's short-sighted for the marginal time and a half you're missing. I don't know. Have you discussed that? Is that an issue that is in this independent contractor versus employee area?
Thanks, Gary. I think that certainly could be an issue, as well as your insurance coverage, what might be applicable or not applicable. But definitely the exposure to liability when we think about not getting the benefit of any type of state law workers' compensation program or your workers' compensation insurance could be a big issue.
Right. And just yeah. Because what you can have as an employer is if you don't have the general commercial coverage for these other type of claims, you're going to be excluded under that because it's in one of your employees, and you're also going to be excluded under work comp because you try to classify them as an independent contractor. But we see it more and more, right? Wonderful. Well, thanks for does anybody have? There was a comment about the interesting history of independent contractors, which is a comment here. There's a whole history of shifting between comp versus non-comp historically, that have been going on for about 150 years in the US. There's a whole labor liability issue too, which we don't want to spend the time getting into. But thank you very much for your presentation. Any other comments, or are we turning to Jill's presentation now too?
Yes,
Or-
yes, yeah.
Thank you.
Okay, I'm gonna share my screen.
Thank you, Jill. And folks, you can keep, just as a reminder, all the materials are in the Google Drive while she's getting going. Remember, all the materials are in the Google Drive that I've shared in the comments, and I'll share again. And then if you have any questions, you can stick them in the chat if you'd like to weigh in on the discussion as well. Thank you. Jill, it's all yours. Thank you.
Assuming everybody can see my screen, okay, and can hear me okay.
Your screen is good and your audio sounds good. Thank you.
Great. So I'm gonna talk to you a little bit about, maybe some of you are aware or some of you may not be aware. The FTC recently promulgated a rule banning the use of non-compete agreements for most workers in the US. So you may be saying, why are we talking about this in the context of estate planning? It does have some impact on the way we advise our clients with respect to business planning, succession planning, and estate planning. So first of all, we use non-competes typically in a way to ensure that the skills that in the training that we provide to our workers don't simply walk out the door. We've got some protection that investment that we've made in that worker stays with us as the employer as long as possible. So that seems fairly reasonable. So why has the FTC banned non-compete agreements? Well, generally, they believe that non-competes are restrictive and exclusionary and exploitive and coercive, that that conduct tends to negatively affect competitive conditions in our labor markets and in our products and service markets. So I've prepared or included a bunch of materials for you. There are a couple of materials that were produced by the FTC. One is a fact sheet, and on that fact sheet, it suggests that as a result of the ban, there will be a significant increase in the number of businesses that will be formed. Salaries of workers will generally increase. There will be a reduction of healthcare costs, and there'll be an increase in innovation and patents, all as a result of this ban on non-competes. There are about 30 million workers that are subject to non-competes right now. And the estimate is that after the ban goes into effect, that number will be reduced down to about 1%.
For law license. Okay, the Boyers from Alba, Missouri, that all went out to play professional ball.
Uh-huh.
Well,
Sorry.
they reached out to Cleat. He was one of them who played for the Yankees, right? He's like, he got to choose the homecoming queen that year. How fucking
Someone,
bizarre is that? I
mute
can't.
yourself.
I'm
I know,
sorry,
here's a good-looking
Jill.
guy,
I'm
though,
trying to
that
do-
makes it
trying-
okay. No, it's
That's
like,
okay.
All right,
thank you for
hold
the
on
honor
for a
of
second.
allowing me to choose your yearbook queen. I'm sure the girls all are deserving to be queen. So I'm picking the girl that I would
I
want to represent me
apologize,
as my queen.
folks.
Miss Vicky, Cadwalder
Hold on.
was my choice. I'm sure
Sorry,
she'll
I
make a very lovely queen.
apologize.
My very best to you
For
always.
admitting
Sincerely,
we're
Cleat.
doing some
I don't
things.
know.
Sorry,
That's
I'm
kind
sorry.
of creepy.
I don't like that.
He was just 17. You
I
know
apologize.
what I mean.
Yeah.
Creepy. And the way she
It's almost as like
way beyond there.
Jill, for some reason,
And I saw.
Madden, we could all hear you.
I'm sorry, can
With a
we,
speedy.
hey, whoever is that, can you mute
Well, then fine. Then
yourself,
I guess I'm
please?
just.
I think it's Aaron Madden. There we go. So all I know is that I want to be queen. So
All right, hold on. Can anybody hear me?
I can hear you,
whoever's talking?
Gary. Yeah. I can hear you.
can hear you.
If you're on and you're not muted, could you please mute yourself? Jill, I'm been trying to mute all again and,
Okay.
Yeah,
Like
Gary,
you.
you can mute all of us.
well, it's the perfect.
As the host, there's a button you can
I
push
got it,
it.
I got it. No, I have it and I did. I was just telling, all right, yes, mute. All right, Jill, unmute yourself, please. Sorry.
Okay. Can you hear me?
I can, and I'm sorry for my minute on the
That's okay.
technology stuff.
That's
Jill,
okay.
can I ask you, Jill,
Sure.
and please continue, this is great, but isn't this non-compete FTC, isn't this a game changer? Isn't this a big deal? Because I've been doing this for, I don't do this regularly, but I've been doing non-compete stuff tangentially for 20 years, and it's totally different. But so please continue. I don't
Yep.
want to bury the lead in our presentations, because this
No,
is
no.
why we put this in, because this is the deal. This is a
It
big deal.
absolutely is. Yeah.
So
it
please
absolutely-
continue. Sorry for my interruption.
No worries. It absolutely is a game changer. You know, many businesses of all sizes use non-competes regularly. Often when an employee that of all the paperwork that you have an employee sign when they onboard, buried in there somewhere is probably a non-compete. There's probably also a confidentiality agreement, and there's probably a non-solicitation agreement. So what we're focusing on is the non-compete part of this, and absolutely the inability to use that non-compete to protect the investment you're making in that employee for the training and the skills you're gonna provide them with. It's absolutely a game changer. It also impacts the small business, closely held business, family business to protect intellectual properties and trade secrets. Succession planning is impacted. So in a family held business, we often use a non-compete agreement to ensure that that key non-family employee sticks around to help us smooth the transition to that next generation of family members for that business. And in the context of parachute payment, so just to back up and kind of discuss what a golden parachute is, it's an agreement between an employer and its worker that guarantees some significant financial benefit if the worker's employment ceases through none of their conduct. So it's typically the result of the sale of a business or changing control. And there's a tax when on excessive parachute payments. We use non-competes so that we can allocate a portion of that exit payment, if you will, to for refraining from performing services, so that we can reduce the amount of the parachute payment and minimize tax associated with that parachute payment. So if we can't use non-competes in this way, then it'll certainly will bring about changes in how these kinds of arrangements are structured. So my colleague, John, is the chair of the valuation committee of our business planning committee. And I would like him to talk about how the inability to use non-competes can impact the valuation of companies.
Well, it certainly can. If you have all of your employees become free agents, and they can get picked off and poached, then you might lose a significant part of your goodwill. Think in terms of, say you have a life insurance brokerage or any kind of an insurance brokerage where it's one-on-one client contact. The sales, any of the account managers leave and go to another company, and they can take their clients with them. Accounting firms, if the CPAs with the client contact can leave and take their clients with them, it can really dramatically lower the valuation of a company. So the appraisers are kind of trying to, generally as a profession, they're trying to figure out how they're going to attack this. And they have reported to us the other day that what they're looking at is, well, let's say everybody competes. What's the hit on the value of the business? Let's say nobody does, and they pick a number someplace in between. And they're essentially quantifying the risk that people might be stolen away from the business. So it can really be a dramatic drop in the value of the business.
Absolutely. So that obviously, if we're talking about valuation, then can be impacted by this, then that impacts the values of gifts, the value of estate tax, and the list goes on and on. So I want to just run through. There are some penalties if we don't comply with this ban. So the FTC can issue a cease and desist order, which typically happens after an administrative hearing. There are consent orders, judicial orders. There can impose civil fines for failure to comply with those orders. It can result in disgorgement, restitution. And those civil penalties are $51,744 per violation of an issued order. And each day that you continue to violate that order, it's a separate offense. So essentially, we're talking about a little over $51,000 per day if you're violating an order issued by the FTC. So I'm going to run through some of the more just the logistics and some of the definitions that are in the rule to flesh some of this out. So there is a notice requirement in the rule. A notice that has to go out to all current and former workers. The effective date of the ban is September 4th, 2024, and that's the deadline for providing this notice. So the notice that you have to provide doesn't require a legal reformation of a current employment contract. The worker just has to receive clear and conspicuous notice that the non-compete clause will not be enforced and cannot legally be enforced. In the rule at section 910.2b4 and in your materials, you have a copy of the actual rule. There's some safe harbor model language that you can use for this notification. I'm gonna put it on the screen. So the model language doesn't state that the worker has a non-compete. It just states that the employer will not enforce any non-compete against the worker. As you'll notice, this is looks pretty generic. It's a pretty generic notice. It's not addressed to any particular employee. It simply has, all cap letters for the employer to insert their name, insert the default, the effective date. And it basically, as I said, it just says you can seek you can seek a job after you leave here, even if it competes with us. You can run your own business after you leave employment here, even if it competes with us. So this is the safe harbor notice. This can be done either, notice can be provided in either hard copy by mail or hand delivery. It can also be done electronically via email or text. And in your materials, there's a very large 500+ page report that the FTC put out, which has got a wealth of information in it. But in that, it suggests that a communication like a mass email to all former and current employees would satisfy the notice requirement. So for former employees, it's just or workers, it's just interesting to note they only require you to send it to the last known contact information. There's no requirement for you to go suss them out and find out exactly where they are. And if you don't have current contact information for that former employer, then you're essentially exempt from having to provide that notice to them. All right, who's subject to the ban? So in the rule, the definition of worker is extremely broad. It's basically anyone who has worked for you now or worked for you previously, whether you paid them or whether you didn't pay them. And there's a long list of titles that fall into this. It can be, and so all of this discussion that Lee and John have been having about employee versus independent contractor does not matter for the purpose of this FTC ban. Both an employee and an independent contractor, as well as an extern or an intern, a volunteer, an apprentice, and even a sole proprietor who's providing a service to someone can fall into this definition of worker, where you would be banned from trying to impose a non-compete on that person. Business entity is also pretty broadly defined, and basically that is whatever business entity that would be subject to the FTC jurisdiction as a whole, they're subject to this ban. So in the center, I've got this special definition for senior executives, which has limited relativity till about September 4th, but it's important to know. In the rule, they have segregated out senior executives and said if the person is a senior executive, which there's a two-pronged test, they have to have annual compensation of at least $151,164 per year, and that person has to be in a policy-making position. The only interesting thing about the annual compensation is that it doesn't include discretionary bonuses. So it has to be non-discretionary compensation, whether bonuses or salary. It also does not include any payments that you're making for that worker on their behalf for life insurance or health insurance. Now, policymaking position is probably the harder one to make someone satisfy that definition. So it's typically going to be someone who's a president or a CEO who has that policymaking authority, but it has to be over a common enterprise. If you have someone who has that ability to make those decisions over a subsidiary or affiliate of a business that's part of a common enterprise, that's not going to satisfy this definition of policymaking. So it has to be the policymaking over the common enterprise. And that person has to be the person making the policy decisions that controls the business entity or common enterprise. So it can't be someone who's just providing advice or exerting influence. It's the person who is making the decision. So typical types of workers that we would want to be subject to a non-compete that likely will not satisfy this definition of a senior executive or being in a policymaking position is that key salesperson or key producer, your division head or department head, and in the context of the healthcare industry, someone who's maybe the head of surgery or the head of internal medicine of a hospital system. None of those folks will rise to the level of being in a policymaking position so that you can make them a senior executive. There are some types of business entities that are exempt. And again, this is based on the overall reach of the FTC's jurisdiction. So the types of business entities that are exempt are banks, savings and loans, credit unions, although it's interesting to note or important to note that federal banking agencies like the FDIC are authorized to enforce the rules of the FTC Act against their employees, and they have done that in the past. General consensus is that those federal banking regulators are going to wait until the legal challenges have been resolved. And we're going to give you an update on those legal challenges as we wrap up. Other types of exempt business entities are the air carriers, common carriers, and then entities that are not organized to carry on business for its own profit or for that of its members, or in other words, most nonprofit organizations. So just briefly to delve into this, the FTC has regulated nonprofit organizations if they are in fact profit-making enterprises. And the FTC has a two-pronged test to determine whether or not a corporation is organized for profit and thus comes within its jurisdiction. They're basically going to look to the source of the income to make sure that that source is has a nexus to the public purpose of the organization. And they're also going to look to the destination of the income, which is probably the more important part of the two-pronged test. And that is they're going to look to see that the net proceeds are devoted to public rather than private interests. So there's a couple of examples in that, and I've put some case sites here just to, you think this, you might be in this world and worried about this, some case citations. There's some additional case citations in that big 500 plus page report that's in your materials. But just a couple of examples. We have a physicians hospital organization that was subject to FTC jurisdiction because it engaged in business on behalf of its for-profit physician members. And then another example is that we have an independent physician association that was subject to FTC jurisdiction because it contracted with payers on behalf of its for-profit physician members for the provision of physician services for a fee. So as I said, this is it's a pretty narrow area, but there could be nonprofit organizations that would be subject to this ban, which may have a pretty significant impact on them. So how do we define non-compete, or how does the rule define it? Again, very broad definition. It's a term or a condition of employment. It can be a contractual term, but it doesn't have to be. It can just be a workplace policy that's embedded in an employee handbook or some other kind of agreement that the employee has signed. The obvious prohibitions are you cannot prohibit a worker from seeking or accepting employment after they've left your employment. You can't penalize a worker from seeking or accepting employment after they've left your place of employment. Those are obvious, but the broader one is the one that's on your screen, is that if that term or condition effectively functions to prevent a worker from seeking or accepting work after they've concluded their employment with you, or if they it seeks to prevent them from operating a business after they've concluded their employment with you, then that also will be unlawful under this ban. So it doesn't have to say, magic words, it's a non-compete. It's just the terms are drafted so broadly that it effectively functions to prevent that worker from being able to get another job after they leave employment with you. Some examples of when this could happen: you could have a non-disclosure agreement that's drafted so broadly that it effectively precludes the worker from being able to work in the same field because they're not able to talk or disclose any information. There are also some things called training repayment agreements. So some businesses require that they've invested money and time in training that employee, and the worker leaves after a certain period of time, maybe it's 6 months. They require the worker to repay the employer. That would be unlawful if the required payment is not reasonably related to the actual cost of training the employee. So that suggests the converse. Yes, Gary.
Hey, I just wanted to give you about a 5-minute high sign here.
Okay.
And we'll go a little over with you. It's all good, but I see some, I'm looking ahead on your presentation. I see some juicy, some great
Yeah,
other
there's some good stuff. We got it.
Well, the whole thing's good. I don't mean to say it anyway, but I just wanted to be mindful of that because thank you.
Thank you. So basically, all of this to say it's very broad, and there are a whole lot of things that, whether you intend them to be non-competes or not, could be deemed non-competes under this rule. So obviously a true non-compete is unlawful. If you have a forfeiture for competition clause,
Can I ask you a quick question though?
Sure, of course.
Does this, and I hate to make it simple, but it's like that old caveman lawyer on Saturday Night Live, right? But sorry. So does this, is there a threshold of number of employees that these FTC apply to, or is it only interstate commerce? Because I know, federal anti-discriminate, there's some laws that apply. Is there a threshold when you're talking to your clients about who needs to work, who can still do it and who can't? I know this is in a later slide too, but go ahead, Jill.
But no, there actually is there's no employee limit.
No bottom limit?
Absolutely not. Nope. So any small business who typically would use a non-compete to protect themselves from trade, for disclosure of trade secrets or confidential information or anything like that, they will be subject to, if they're subject to FTC jurisdiction, and most companies are, they will be subject to this ban.
Now everybody's like lawyers, right? Because lawyers could never have this before. All right, Jill, sorry, please continue. I ate into your time. Thank you.
No worries. There's just a couple of things under the forfeiture for competition, some things that are okay, just so that you know. If you pay a worker a sign-on bonus and require that worker to pay that sign-on bonus back if they leave earlier than they're supposed to, that is okay. As long as basically the key is, have you prevented that worker from being able to seek employment after they've left your work? So the garden leave payments, I think, are going to become popular. So a garden leave payment is basically you're paying someone to sit on a couch. They're not competing with you. They're also not providing services to you, but they're still technically an employee of that company. And you may pay them for 6 months, basically, to sit on a couch. Those are okay, as long as after you finish paying them for that 6 months, you don't prevent them from being able to seek employment anywhere that they want to. What's also still lawful, obviously you can still have those non-solicitation clauses, those confidentiality agreements, but you need to be mindful that they are not so broadly drafted that they effectively prevent a worker from seeking employment. There are a couple of exceptions to the ban that I just want to talk about, the high ones. A bona fide sale of a person's interest in a business. If there's a non-compete in connection with that, that's going to be an exception to the ban. There's also, Gary, you might find interesting, there's no threshold to that. There's no minimum percentage of ownership to qualify for this exception. So you could have a 1% interest in a business. If you want to try to wrap a non-compete around that, you can do that.
Is there a minimum on the garden payments too, when you're paying?
No, in fact, interesting. Yeah, the garden payment is really just nothing in the rule even talks about garden payments. It's just been anecdotal, and the FTC got comments asking about garden payments, and they essentially, sort of punted and said, we know they exist. We think they're fine. We're not going to opine on every single fact-specific detail of a particular garden leave payment, and essentially said, we think they're okay, but it could rise to the level of a non-compete without much detail behind that comment. So we talked about senior executives, and I said that definition is only important until September 4th, and this is why. It's because if you have a senior executive that has a current non-compete, someone who fits into that two-pronged test, remember it's the annual compensation and the policy-making position. If they're under a current non-compete, they're an exception to the ban. So that non-compete can stay in place. And then if you're a franchisee and a franchisor relationship, there's typically non-competes in those relationships. Those are also exempted from the ban. All right, so what do we do going forward? I think it's important for everyone to review current non-competes, identify senior executives, review your employment agreements, deferred comp plans, equity comp plans, shareholder agreements to see if there's any hidden language in there that may function as a non-compete, even if you didn't intend for them to. Maybe look at your NDAs and non-solicitation clauses to make sure that while your trade secrets and confidential information, intellectual property is protected, they're not drafted so broadly that they effectively function as a non-compete. Obviously we've got a notice requirement. So I think you need to think about what notice, what language you're going to use in the notification to the workers, the method that you're going to use to communicate this to the workers, be it hard copy, electronic, mass email, and then of course determining the timing. Most people are going to wait till the last minute to do this because there are some legal challenges, and we may get we may have a preliminary injunction in place, but until then, I think you have to move forward assuming that this is going to have to be done. Planning opportunities in the few minutes I think I have to wrap up. Obviously, identify your senior executives, if you have any, that are not subject to a non-compete, and try to put one in place prior to that September 4th deadline. You could try to create senior executive status between now and September 4th by paying additional compensation, adding responsibilities. But remember, those are pretty, those are the additional compensation has to be non-discretionary. So you can't just give someone a big bonus and force them into that compensation, that higher compensation category. And the responsibilities have to be policymaking over the entire enterprise. You could create an ownership opportunity. So the rule doesn't say whether a member or an owner could fall into the definition of worker, but clearly someone who's got an ownership opportunity, you could put them subject to a non-compete based on a future sale of their interest in the company. You could consider converting your current non-compete agreements to garden leave payments instead. Again, non-solicitation, non-NDA agreements, making sure that they are robust enough yet not too broad. And then time-based vesting schedules. Basically look at other ways to encourage long-term employment, whether that's phantom stock plans, additional bonus plans, some other way to encourage long-term employment other than a non-compete agreement. Since it's just a couple of states, state laws, several states do have state laws that ban non-competes that in addition to this federal ban that's going to come into place. And just an update on the legal challenges. There are 3 cases that have been filed. The first one, Ryan versus FTC, papers have been submitted. The judge has decided that he doesn't want to hear oral arguments, so he's going to decide that request for a preliminary injunction on the papers that were submitted by Ryan and the FTC and some other parties that submitted papers. And then the second one's been stayed pending the results in Ryan case. And then the third one in Pennsylvania, that has a hearing is scheduled for July 10th, and the court has indicated they're going to rule on the request for preliminary injunction before July 23rd. So hopefully, I think we will get something before then. I think general consensus says the rule's not going to survive in its current form. I think it could survive in some current form. We may get a preliminary injunction to get some relief from the notice requirement by September 4th. But like I said, I think it's wise to go ahead and go through all of these agreements, and just make sure you at least know where your exposure is, depending on the outcome of these legal challenges.
You think this is gonna stay? This is gonna stick, this ban, Jill?
I think that if it doesn't, I think there are enough states that are jumping onto this bandwagon. There's probably about 10 states now that already have some form of ban on non-competes. And so I think the federal rule, if it doesn't last, I think we may see more state laws, states that are going to jump on this bandwagon. So I think we're going to have curtailed use of non-competes in some form or fashion.
And
I
folks,
think that's a reaction to knee-jerk, I think a lot of employers, it's a knee-jerk reaction. They have every employee sign a non-compete. And I frankly, I'm not sure that it's necessary in every single case that it's being used. And I think that's what this is a reaction to.
yeah, no, I hear you. And we'll see where the pendulum lands as it goes back and forth. It'll be interesting interplay. Everybody keep watching it. With the Supreme Court taking off Chevron, you may have lack of deference to the FTC. And then you have state law. So there's so many things that are interacting here. I'd encourage everybody to follow the law. And then, just knowing John, Jill, Lee, and John a little bit here, they'll take emails from you, they'll answer questions. They'll give you updates, that kind of stuff. They're in this space. So I'd encourage you guys to any of the attendees here to please read the materials, but also reach out to these folks who are in this space. So again, Jill, Lee, and John, thank you so much for your wonderful presentation of all these issues. This is a lot to do in an hour, so thank you.
Yes, yeah, you're welcome. Thank you.
Thanks for cutting it down too. Thanks for cutting it down. Well, folks, because there was so much to go to and we packed 3 experts into 1 hour, we're kind of just button up to our last presentation right here at noon. So I'm going to go ahead and move to that without any further ado. Let me introduce Mike Downey. Mike Downey is kind of recognized, not kind of, don't mean to kind of you, Mike. Mike Downey is an old friend of mine for 20 plus years. Mike he's the area expert in all things legal ethics. That's what his practice is devoted to, as well as litigation and other things. Mike lectures 20 to 50 times a year on legal ethics. I've heard him, he's spoken with me many times. And so he usually goes real fast and has an amazing PowerPoint. So Michael, you may unmute yourself here. I'm going to ask you to unmute and you're up, sir. I'm going to put in the comments. I'm going to put Mike's bio, his stuff. I will tell you just like I said with these other folks, Mike answers people's questions all the time. Mike knows these things. He's able to do these fastly because he knows these regs and these rules and all these opinions inside and out. Sorry, Mike. Go ahead now, sir.
Well, thank you. Welcome, everyone. Glad to join you. And actually, this is my 4th presentation out of 6 of the week. So when Gary says that I present a lot, I definitely do. And it's good to see Gary and good to help legal services today. So I appreciate you all being here. The topic for today is the ethics for estate planners, and I'll be talking about other things as well. I thought sort of a nice segue from the prior presentation is just to remind everyone that lawyers are not allowed to have non-compete agreements. For other lawyers. In fact, you're not allowed to ask a lawyer to enter a non-compete agreement when they are leaving a firm, nor are you allowed to enter one. So there's some question and frankly, some gray area with regard to in-house counsel, but certainly for lawyers moving between private firms, they are generally void. So it's kind of an interesting place to be in. And I can tell you that, law firm divorces are something I keep very busy with, where lawyers are looking to leave firms or break up firms. And one of the things that I always tell people right off the bat is your non-compete is not going to be enforceable. So I always used to tell people we're the only profession that can enforce non-competes and the only one that actually doesn't have non-competes. There are a few others as well, but we certainly stand out above the others. As we get started here today, I've got kind of a 2-part program. The first part is going to be talking about some things you can do to protect yourself with a focus on estate planning lawyers. And then I'm going to get into some scenarios at the end. And I will say, I know I'm supposed to go until about 12:50 or so. I don't feel like I have to get through every slide. But as Gary mentioned, I do talk very quickly. And I always say, well, if nothing else, it helps keep people awake. But I will tell you, I actually outrun most court reporters, which is not a great thing to do when you're a litigator. So with that, I'll get started. So the first thing I just like to start with is something that we probably don't think about very often to practice, which is sort of ironic for those people who do estate planning. Because of course, when you're doing estate planning, you're helping your clients prepare for a risk that could occur at some time, that, you know, something may happen to them. And is their property going to be properly taken care of? Is their family going to be taken care of? What other interests do they have want to have taken care of? And so just to turn that around and ask it to lawyers, if something unexpected happens to you today, what happens to your clients? It's sort of interesting. At my solo practice has been open since February of 2015, and I've had several clients die. I've had clients go through all sorts of other experiences, including significant medical events. And this is something that, you know, no one likes to think about, but certainly something that you may want to spend a few moments thinking about sometime in the next few days. So in that context, you know, it is good to have an emergency practice plan. And that doesn't need to be a whole lot of things, but you do want to make sure that someone has the ability to come into your firm, to get access to your computer, probably your phone and your bank accounts, et cetera, to make sure that any money that's being held in the trust account is going to be refunded to the clients or dispersed to the clients or third parties who should receive that money. And also things like getting access to emails and things. You know, the reality is that some of us do have someone in the office that can help bridge that. My wife knows that if something happens to me, to talk to Paige Tungate, who's my attorney colleague, and Paige can certainly manage a lot of things, although there certainly are some matters that I have that Paige doesn't really know about. And, you know, it would definitely be a struggle, but make sure that you've at least thought about how you're going to do that. And also think about your emergency plan for your office. In recent months, I had a lawyer call me and say that their office actually had been probably subject to arson. And it caught on fire. They had lost almost everything. And again, that question of, okay, you know, if that type of thing happens, or if there's water damage or something else, you know, think through what you can do to make sure that you've gotten ready for that. One of the interesting arrangements that a lot of firms do consider is having an arrangement where they would be able to use someone else's space for a while. And this may seem somewhat counterintuitive, but often it is best to share space, or, you know, obviously most people can work from home now, but if you are going to share space, to talk to a non-law firm. You know, maybe you'll need conference space to meet with clients. Maybe you'll need some sort of place to gather your people. Make sure also you have things like that you have the contact information for your attorneys, for your colleagues and staff, that you can reach out to them and make sure that everyone knows what's going on and what the plan is. So, for example, in the office lit fire, the office director was able to text everyone and say, hey, you know, you may have heard their office caught fire last night. It was on the news. You know, here's where we're going to meet. Here's what we're going to do to try to keep things moving forward. And certainly that's a good type of idea and something that you really should consider as you think about your own practice. In a related context, you know, one of the things also that we don't necessarily talk about as much as we should, and I saw this as a nice opportunity to at least mention it, is to, you know, make sure that you're doing something to maintain good mental health. Part of that, of course, is you know, doing the basic things of good health and good hygiene, of, you know, getting good sleep and eating well, you know, making sure that you are getting some exercise, make sure that you have some hobbies or something that is not your work. A lot of times for lawyers, you know, when you ask them what's your hobby, they say practicing law, and then you say, what's your job? And they say practicing law. And, you know, the answer to every question is I practice law. That's often not a very healthy situation to be in. The legal profession has a much higher than the rest of the population incident of things like depression and anxiety. I can tell you in my practice, that's often a very common thing that occurs. In fact, one of the things I would just say in general is, you know, if you've got that thing that you really are having trouble dealing with, which in my business, I don't know if it's an official term or if I made it up myself, but I refer to them as kryptonite matters. And you know, if you know Superman, you know that anytime Superman's around kryptonite, he loses all strength and can't do anything. It seems like lawyers often have that matter that, you know, they've got 15 things to do, and that matter's always the 15th thing and never gets done. This often results in missed deadlines. It often results in lawyers feeling they need to be dishonest about what's going on with the case or something else. And that can cause a lot of problems. I've had a number of discipline cases recently. One case where the lawyer settled a case without proper client authority. And the disciplinary counsel's office looks at these things very seriously. So again, the more you can do, and one of the things, frankly, is if you've got that type of case, to share it, to share it perhaps with a colleague or a friend or a mentor or some other support, and be able to say to them, I keep neglecting this case, and today I'm going to commit to you that I'm going to do the 2 or 3 things that I really have to do to get this case on track again and to keep it moving forward, to do that. One thing we also used to kind of joke about was what we would call the dog cases. And part of the reason for that is because they do it disproportionately involve dogs. And when I used to tell that story, I actually had a case involving a dog. I don't right now. But one of the ideas you can also do if you do work at a firm is see if you can swap cases. I always joke that the client that you hate talking to and that drives you crazy, when you hand that case over to your colleague, suddenly they become one of your colleague's favorite clients, and they're baking cookies for your colleague. And that, they'll say things like, boy, Paige is just so much smarter than that Mike guy. I don't know why we ever had to talk to Mike. Paige was the perfect one. And of course, I'm then handling the client who was frustrated with Paige, and they're saying, Mike is so smart, I don't know why we ever had to deal with Paige. So think if you can swap off those cases and get things moving. And the other thing
Mike,
yes.
it's great. I tell that to people all the time. A problem shared is a problem halved. A problem shared is a problem halved. And I remember when I was a puppy lawyer, they used to say that file in the corner, we call it the dog with fleas. We used to call that 30 years ago, because that's the one you never touch, and it's the biggest thing you have. And I was looking around while you were talking for my First Things First book. Remember that Stephen Covey book where he talks about the areas? Remember to, make your, and I always tell my lawyers that work for me, a problem shared is a problem halved, and make your hardest phone call first. And then the rest of the day is easier. Sorry, Mike, go ahead.
No, absolutely. And there's a version of that theory known as the swallow that frog, that apparently Mark Twain said, start your day by swallowing the biggest ugly frog you have to eat that day, because then you'll know everything else the rest of the day will be more pleasant. And again, if it's that neglected matter, it's a great one to start with.
The Mark Twain quote I use now more and more is, if I had more time, I would have written a shorter note. So as I get older in my legal writing, I just less and less, I write less and less, or I try to. Anyway, sorry, go ahead, Mike.
No problem. And then the last thing to mention on this particular topic is the Missouri Lawyers Assistance Program. There's a lot of.
I put the link in the chat, Mike, and I see you did it. Sorry, Mike, go ahead.
Oh, no, perfect. Well, and just the real mention here is that, this is something that your bar dues are paying for. It is free mental health and substance abuse and similar services for lawyers, for their staff, for bar applicants. It encompasses, lawyers seeking reinstatement. There's a lot of people covered by this, and it's a great place, if nothing else, to start. And one of the things I really like about the Missouri system is that, and I do a lot of lawyer discipline work. If I have a lawyer, contact, it's called MOLAP, or Missouri Lawyers Assistance Program. If I have them contact MOLAP, I know that the disciplinary counsel's office is not going to go to MOLAP and ask what happened or anything else. Usually what we'll do is we'll get simply something saying that, the lawyer has communicated with MOLAP and is following the treatment plan, or the, plan that MOLAP has laid out for them. And that's the end of the conversation. So it really is confidential. And the nice thing also is if you use a private physician or, private healthcare provider, there's always questions of, is it a good enough plan, or, will it be adequate? If you're using MOLAP, OCDC generally accepts that what MOLAP thinks should happen is going to be sufficient. So it's an easy way to deal with those things. And again, it's an open door and an open gateway for you if you do need help with anything. And the last thing I'll mention on this again is, it's amazing how disproportionate the legal profession is affected. If you feel like you are alone in dealing with your issues, you are not at all. And really, the more proactive you can be in maintaining good mental health, the less likely that things will happen where you may need someone like me. So I really do encourage people to get the help they need. Then, of course, there's the idea of protecting your practice. And the one issue I wanted to just talk about quickly here, because a lot of times people don't really understand it. In fact, actually, I got a text from a lawyer today about it, is, they said, we're renewing our insurance policy. How much do insurance we need? And there's a couple of things to know about malpractice insurance. The first one I mentioned here is that malpractice insurance for lawyers is almost always, and I would say always, but maybe there's that one exception that I've never encountered, they're claims-made policies. And so if I, do some legal work and say I do that legal work in 2020, and the client writes me today and says, Mike, you messed up my case, or you messed up my estate plan, or my documents, or whatever, and I get that letter today, June 2024, the key question will become, do I have insurance in June of 2024? And did I have prior notice that that claim was coming? And if the answer is no, I didn't know the claim was coming, the policy it will attach to is my June 2024 policy, which means you need to make sure that your current policy will protect you for past work. When lawyers are doing things like changing firms or moving in-house or retiring or doing whatever, one of the dangers there is that your claims-made policy may not provide you with the protection. And this is very different than most insurance. Most insurance is what's called an occurrence policy. For example, if I have an auto accident in 2020 and I get sued over that auto accident, my insurance back in 2020 will protect me. You know, I may have stopped driving and not have insurance now. That doesn't work that way with legal malpractice. The other thing is, you know, the question of how much should you have? You know, one of the things generally that I tell people is think of your largest case that you handle, and then imagine if that case really goes south. You know, you make the mistake, you miss the statute of limitations deadline, or, you know, something horrific happens. How much is that claim going to be? And then unfortunately for legal malpractice policies, you then generally need to add a little bit of a cushion. And the reason for that is most what we call LPL, or lawyers' professional liability policies, are what we call burning policies, or there's a couple of other names they're used, but basically what it is that the cost of defense is deducted from the amount available for settlement. So if I have a case, you know, I've got $1 million policy and we litigate the case, and my defense counsel run up $200,000 in bills, I'll only have $800,000 left to settle the case. So if you figure I'm going to have, you know, I handle $1 million cases, maybe I need to have $1.5 million or $2 million to make sure that I'm fully protected. I will tell you my own policy is actually not a burning policy. It does have a separate amount available for legal fees, and you can certainly pursue that type of thing if you'd like. The other thing I know a lot of times lawyers feel is that malpractice insurance is really expensive. And I can tell you it's actually not. You can get a policy that will likely cover most of what you would need for about $100 a month. So, you know, it's not necessarily a big thing. And then you'll see there also the question of claims and pre-claim. Usually a claim is when someone actually indicates they think you've committed a malpractice, or that you have, that, you know, they make a demand for money or something similar, or they file a lawsuit. And that's when that claim starts. There's also issues of coverage for pre-claims, and the most common one in my world, frankly, is bar complaints. Sometimes if you get a bar complaint, you do need to notify your malpractice insurer, because your malpractice insurer will say, well, at that point, you should have had notice of a potential claim. So again, that comes into play. But also a lot of policies do provide money that will help cover the fees of having someone assist you in responding to the bar complaint, including, as you can see there, sometimes it's $25,000 or more, which can get you well through the process. So again, you know, one of the things that's sort of odd is I always tell people, you know, if you've got something out there that you think could end up a claim, it really doesn't hurt you to give notice to your carrier of it. It's called a circumstance. It usually does not increase your premiums. I think in the last year, I had 2 or 3 instances where we got weird communications from clients. We didn't think we had done anything wrong, but I thought, you know, I'm going to notify my insurance carrier, and then I don't have to worry about it anymore. I can go on with the rest of my life. And you know, I've given notice of several circumstances and never had them grow into more than that. I'm very happy about that. But, you know, again, it's better to tell your insurance company to be protected.
Can I underscore that? Because if you have a complaining client and then a year later they make a claim, and the insurance can turn you down because you didn't make it in a timely manner. You have a duty to cooperate, duty to notify your insurance company, especially with renewals and stuff. So even if you don't think it rises to that level, or if you think the client's complaints are BS or something, it's amazing what an old email may look like a year and a half later and say, no, they complained about this. Actually, you didn't hear it. You read it the other way. If you have a claims made policy, use it and put them on notice. If it doesn't, I won't worry about, whether they're going to increase your premiums. But look, if you don't have a claim, you go to another policy. So that's why this claims made is so key. Sorry, Mike, go ahead.
Oh, no, absolutely. Absolutely. And, you know, just to explain it in case you kind of missed it, if we were talking about, you know, you can see here a timeline with work done, demand letter received, and settlement paid. The key question with a claims made policy is what you have in that middle section, the policy B. And so that's going to be the one that governs. It's not when the work is done, which would be an occurrence policy, but rather when the demand letter is received. And the other thing to mention here is something called a tail policy. And a tail policy would be where, you know, say that you did the work in period A and then you stopped practicing law. So there would be no further periods here. A tail policy is the term used that extends the time that you can notify the insurer of claims that were brought under that first policy. So that's a common thing to use If you're changing jobs, you should consider whether you need a tail policy. And part of that is because a lot of times firms will, firm policies will say, we cover legal work done at this firm from this date to this date. Well, if you did the work at a prior firm, sometimes there's arguments of whether or not there will be coverage, but also things like retirement. Different policies handle it different ways, but many insurance policies actually have a provision that says that if you, are leaving the practice of law, you can automatically get a tail policy under the policy that you currently have, and it will specify how the payment will be and how long that period will be. And usually, again, it's about the typical cost of a tail is about 1 year of coverage. So if you are leaving the practice of law, you're really just paying 1 more year of premiums, and a lot of times you'll get another 5 years of coverage to notify them of any claims and get coverage. So
But
certainly, again,
look at the amount. Sometimes the tail coverage is lower, and they do that with doctors and med mals all the time. So be careful of that. You don't want to pay for something and only have 50 grand in coverage for 3 years, because that might not help you.
that's probably not enough.
Depending on the type of practice you have.
Particularly if you do have that burning or eating policy where, as we all know, if getting through discovery is going to cost you $50,000, and, if you need money to settle the claims, it's not going to be there.
Or an eroding policy, also called. Thank you, Mike.
Yes.
Go ahead.
Sure. And then, this is just sort of the update on what's going on. And this particular survey, they're discussing the Ames and Goff survey. But interesting things they talk about here is, 11 of 13 insurers polled have participated in claims payouts in excess of $100 million in the past 2 years. 5 insurers surveyed paid a claim between 150 and 300 million. And this is really just talking about, what's going on in the insurance industry. The reality is that clients are more likely now to sue lawyers than they were. And we're seeing much larger settlements and judgments. And the interesting thing also included in this little blurb is notice that conflicts of interest remain the single largest cause of legal malpractice claims. Then you'll see their scrivener or clerical errors are also very common. So, just realize that that's the type of things that you should be looking for when you do want to avoid claims. And I always say there aren't many legal malpractice jokes, but here's one for you. What do you call a legal malpractice claim with a conflict of interest? And the answer is it's a case you settle. And the reason for that is because, of course, if something has gone wrong and you did have a conflict of interest, it's going to be very hard for you to explain, yes, we made this mistake, but it wasn't because of the conflict of interest. The jury, the finder of facts, very likely going to look and say, well, you had that conflict of interest. That was probably part of the problem. And then the second part, and the reason it's actually a joke, is what do you call a legal malpractice case where the lawyer has a conflict of interest, but also a conflict waiver? And the answer there is it's a case you settle for less. So you settle cases where there's a conflict of interest, and you settle cases where there's a waiver for less, because again, it's not probably going to cure the problem. And waivers are sort of tricky and tough. Often they're, it's hard to write a perfect waiver. And then you can see here also for multiple years, the survey has found the same 3 practice areas generated the largest number of legal malpractice claims. And since I was doing this program on ethics for estate plan, you can see that the number 1 area was trust and estates practice. Number 2 was business transactions, and 3 was corporate and securities matters. And then you can see there's been a significant growth in the insurance defense and personal injury plaintiffs work. But again, estate planners for a long time have been the number 1 area. And frankly, it's a tough area to be in because, of course, if you do make a mistake, there's a good chance that it won't be discovered until years later when someone dies and then people don't get what they're expecting to have. The other thing that's sort of interesting about it is generally only clients can sue, but there is some case law in Missouri that supports that other people can sue, particularly where they were intended beneficiaries and it's an estate and trust practice claim. And you can see there, that's the Donahue versus Sugar, Thompson, and Kilroy case from 1995. And when we do talk about claims against lawyers, we've got legal malpractice claims. We also have what's called a breach of fiduciary duty claim. And under Clemmy versus Best, you do have to have a separate set of circumstances. Although I will say, when I do file plaintiff's cases, I typically file both legal malpractice and breach of fiduciary duty and let the court decide which one it thinks should proceed, because courts are kind of different on that. And then the last thing to mention here is cyber-related claims. There's been law firms have been identified as a major target of cyber claims for probably now a decade. It has only gotten worse. And one of the realities of things is that if people really want to damage your firm, through cyberspace, they're going to probably have the power to do that. So be forewarned. And many insurance policies do provide some cyber-related coverage, but you really need to look at that as well, because they're very careful as to what they'll cover. They're very inconsistent as to what claims will be covered, what they'll pay on. Sometimes it will be things like they may cover access to your client files, or they may cover when, something has happened where, for example, work transactions where someone, gets involved and interferes using the computers, but they may not cover a lot of other things. So just be aware that you may want a rider there, you may want some other sort of policy. Consider how you're going to cover yourself on cyber claims. And then we mentioned before, but just quickly to go through, conflicts of interest, failure to gather sufficient information, believing the client without verification, neglecting communications with the client, and undue influence by potential beneficiaries. One of the big things I would also say to people is sometimes lawyers don't want to put things in writing because they don't want to embarrass the client, and I think I actually mentioned this later as well, but this notion of doing a memo to the file is pretty worthless because normally it's the client that needs that information. So if you find yourself writing a memo to the file to explain what happened, really think, should I instead be writing an email or something else to the client saying, hey, I know you're making this decision. I know you're going to give all this money to this person. I know you're going to do whatever. I don't think it's appropriate. Here's what I think we should do instead. Go ahead and be willing to say that, and realize there's sort of the old comment of, every good lawyer has been fired at least once, and realize that sometimes the risk of being a good lawyer is that you are going to tell someone something they don't want to hear, and that you may lose that your job or your client or whatever. Things for drafting errors, and this only becomes more and more of a problem as we rely more and more on technology. Over-reliance on standard forms, intermingling imprecise terms. I always tell people, if you define a term, use the defined term and really make sure it's careful. Failing to discuss contingencies where, what happens if the other party goes bankrupt? What happens if the other party is acquired? What happens if the government gets involved or the activity is illegal or whatever it is? Think through those types of things. And for example, one of the things I really emphasize to people is don't treat settlement agreements lightly. Make sure that you're very careful in how they're drafted. Make sure they do what they need to do. Often those are some of the most important documents you can have out there. Consider how you're going to address changes in the law that may result. What are we going to do? Am I telling you at the end of this, I've prepared your estate planning documents and I will not contact you again if the law is updated? Or do I say, we'll provide you with annual notices and see if you want to review your plan, and whatever you tell people you're going to do. Then you can see there also failure to conform or coordinate documents, or failing to properly affect the testator's intent, all common drafting errors in the estate planning practice. Then other errors, problems, and lack of execution. One of the big issues that comes up is, should we video a person who's executing a document? And you will find there's lots of differences of opinion on this. Some people say, I video every execution of documents. That the question then doesn't become, are you videotaping this one because you were concerned about it? Some people say, I never videotape them because I can be a witness, but I'd rather not have the videotape out there. Think about that. I don't have a strong feeling one way or the other, but in conversations I've had with lawyers, there are certainly instances where we have said, there may be concerns and we think here it's worth videoing, even though we don't video everyone, because we recognize it could be an issue, and we want to provide our client with the best possible evidence they would have of their capacity in order to protect their interests. You can see there are also changes in the law and fraud, overreach, and self-dealing. There have been changes made to ABA Model Rule 1.16 that talks about now that if a lawyer in taking on a representation, they should get to know their client and know some of the information involved. This is actually coming out of international efforts to prevent not bank fraud, money laundering activities, sort of the big first place for it, and other financial crimes. But really, it's a critical thing for lawyers to think about, particularly in the context of estate planning. I've seen a number of bar complaints that have arisen where, at the last minute, someone needed something done. They call the lawyer drops everything to try to help them. And, in doing so, some sort of mistake is made. And the reality is, you really think you're helping and saving someone, but they're still going to be willing to file that bar complaint. So, be very, very careful. The other thing, sort of sloppiness and things. I'm a notary. I've got, pages of notary. My son's probably going to become a notary. And the one thing I told as a notary is, whatever you say in your notary block needs to be true. So if you say the person appeared before me and signed, you need to be able to say they appeared before me and signed. I tell people, if you're going to sign a document in front of me, I want to see the blank signature thing. I want to see you moving the pen. I want to make sure there's a signature. And I've seen so many malpractice cases, ethics cases, et cetera, where someone, stated, oh, I can notarize this. And it turned out for whatever reason that got called into question. including I've actually had one where somebody notarized a document that someone apparently signed after they were dead, and it did not go well. It was a malpractice settlement. So, you know, people don't think of notaries as being a big deal. The sole reason you exist as a notary is to verify a signature. And if you're trying to say, you know, I never saw the document signed, but I'm going to verify that anyway, that's a danger you do not want to be in.
Can the notary change the affidavit and say, they called me on the phone, said this was their signature, so I did it? Because now with DocuSign and some of the ways we're signing things, can you change your affidavit as a notary to make it more accurate or accurate?
You can and you should, including that actually, and I haven't seen if the new regulations require this, but originally when COVID broke out, Missouri did not allow for virtual notaries.
Right.
And so as a notary, one of the things we were faced with was how do you do it? And it is permissible to do notary through Zoom or FaceTime or something where you can see the person signing. There you were actually instructed to put, you know, through Zoom pursuant to and then cite the executive order of the governor. We still, when I'm doing a signature block, I will put on the thing, you know, how I did it. And I will also write in my notary book, you know, this is how it was done. So if someone came and said, you know, Mike, you notarized Pat Smith's signature, you know, I'd say, yeah, it was by Zoom and we did it, you know, at this time on this day. And that's, you know, obviously, you know, 10 years from now, I may not even remember that I even met Pat Smith. But if I pull out my notary book, it's going to tell me that. And yes, you know, not only can you do that, but you should do that. If it says, you know, appeared personally and signed, if they didn't appear personally and signed, either you change that or you don't notarize it. So.
Great points, Mike. In fact, you know, we do that. We do a lot of virtual stuff, but I frankly, on some of our forms, I wonder if we change them all or if all my paralegals do. So thank you for the point.
And I even saw the case where, you know, the father's name was John Smith and the son's name was Michael John Smith, and he went by Michael Smith, but he signed John Smith, and the notary notarized it. And they said, you know, you had dealt with John Smith. You should have known that Michael Smith wasn't really John Smith. And, you know, malpractice claim resulted. So be careful, be really careful and think through, you know, don't take the notarizations lightly like we so often are tempted to do. Engagement agreements, you know, who is the client? Make sure it's very clear. If someone is not your client, you need to, beyond perhaps putting that in the engagement agreement, which is fine, you need to make sure that person actually knows. You know, if you've got 3 kids, Abe, Beth, and Chris, and you're going to represent Abe, but you're not going to represent Beth and Chris should get some sort of communication from you, preferably in writing or an email or some other evidence that says, I'm not representing you. You all may want to get your own lawyers. My only client here is Abe. And, you know, what will be done for the client, the more specific you can be, the better. For joint representations, it's not quite an always, but it's pretty darn close to an always that you should at least have some sort of language that, you know, you're aware that you're both being represented by me and that there are some issues. And usually what you're going to have to deal with is what I call the zeal conflicts. You know, you guys may disagree on the outcome, and I'm only going to be able to pursue one outcome, or you're going to have to agree on them, which could be something you don't want to do. And also confidences. How are we going to handle information? If you share something with me, am I going to tell your co-client or not? Those are the 2 things you generally want to address. And then the last thing there, you know, implementation of the estate plan, spell out to people what you're going to have to do and how things are going to get done.
Hey, Steve, you got a question?
So yeah, the Corporate Transparency Act, a lot of people have been asking about what they should do in their engagement letters for that. And our firm has generally said that we don't want to be responsible for the filing itself, because if any information changes and you have to update it, then we might be able to be held liable. So we would generally carve out and say, we will advise you as to what needs to be on the form, but it's up to you to fill out the form. And a lot of the registered agent companies will do the filings for clients, and usually they'll only charge maybe $200 or $300, and so it actually is cheaper for the client to have to work with a service company than it is for us. So I sell that to the client as the client benefits by lower fees, and of course we benefit by not having a liability.
Sure, and frankly, I think that does make sense. That's one of those, you know, small tasks that could create bigger problems. I will tell you, actually, I did my own Transparency Act filing for Downey Law Group, and it didn't take that long, but I, you know, had to pull my documents together, and you know, I think that's a reasonable way to do it. And again, you know, it's interesting. For more than a decade, the American Bar Association has been getting pushed primarily by federal law enforcement agencies to do more related to know your client and disclosure of things. People may have heard, but the US is seen as one of the best places for money laundering because of how we handle LLC ownership, that it's very opaque and very hard to figure out who owns what and things. I think, if people were to say to me, what changes will we see in the practice of law in the next 5 to 10 years? Certainly there's a lot with technology and artificial intelligence and things. But I think also this is one area where the organized bar is going to continue to lose ground. That lawyers are going to be expected to do more and more. And I think your idea of, telling the client you need to make sure everything is done properly, but not necessarily agreeing to do it all for them may be a safe path.
Yeah, and we put that engagement letter, and we also include the fact that there's penalties and possible imprisonment for not complying, so they know to take it seriously.
Exactly.
Another thing you kind of mentioned about the joint representation. So when I represent parents, sometimes I'll represent the children too, and so I will, after having a verbal conversation with the children about this, I'll put in the engagement letter with the children that if the parents change even though we might have family meetings or whatever, that if the parents change their estate plan, we're not necessarily going to tell the kids about it. And I expressly put the example in that if mom cuts you out, you can't rely on us to tell you about it. And I put that in writing in the letter as a tried to have a good example of a kind of a horrible of horribles.
I think that's also a very good approach. And there is an American Bar Association formal opinion that indicates that if you represent the parents and the children, you may not have an obligation, but you're inviting people to try to distinguish the facts there. And of course, ABA opinions aren't mandatory authority. So I think you're smart to include that type of language.
Thanks.
But before you leave this area, Mike, as someone who is not in the ethics space like you, but I've sat on the disciplinary committees for years. People don't understand, if they're in a meeting with a lawyer, they think you're their lawyer. So this is I've just seen a lot of these, and you talked about this estate planning being one of the big malpractice areas. I just want to highlight this for the audience, is saying who's not your client, the beneficiaries, successor trustees, these other things. This is a whole thing, and it's best to be clear going in and make that part of your system in your firm, like Steve does and other people. Make that part of your system. Have a set engagement letter that you use, but you want to edit it for other people, and there's a lot of other things. Sorry, I may have stolen some
absolutely.
points, but
and I
mean, I always complaints, and people don't understand. Like, I was in a meeting and I thought this is my lawyer, and my guy I was going to marry died a month later, and and Steve puts an example of a boyfriend girlfriend in the comment that he had years ago as well.
Yeah, no, I mean, very, very true. And I apologize. I actually thought I was following the comments, but I'm not. I've seen circumstances.
You're good. I'll catch you up if you don't. You're good.
Good. Where people are, a lawyer meets has their client present, meets with someone else, and then, they talk to the person, and subsequently they want to, depose the person or sue the person or something else. The person's going, wait a second, I thought I was your client. Those are the types of nightmares that result in my world. I had a case recently where it was a multi-partner firm, and one of the partners got in trouble, and the other partners wanted to expel him. And, I had to think through, okay, who's my client here? Well, I don't want it to be the firm, because the firm includes the guy they're trying to expel. So I agreed to represent the other guys who, were looking to get rid of him. And you can quickly see that, there's a lot of circumstances like that. As a lawyer, you should always figure out very quickly who's my client. And if you can't answer that question, you say, let's stop here for a moment. Let's figure out who I represent and who I don't represent. And again, make sure you communicate that, I don't represent all these other people in the room. Because again, if you put that in your engagement letter, you say, I don't represent the beneficiaries, blah, 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 blah. Well, if you've been meeting with those people while you've been meeting with mom or dad or whomever, the children have been present, those are just invitations for people to say, oh, I thought they were my lawyer too. And now mom has changed her estate plan, and nobody told me. And I had shared all this information with a lawyer about what I planned to do with the money mom was giving me. And, it's a breach, and you just don't go there. Take care of yourself on the front end.
And later, and there's a lot of experienced lawyers who don't do this, who've already done this, but if you're not, if later confusion comes up, let's say you didn't do it perfectly the first time, or you're in a meeting later and someone says, don't risk, you want to keep the client, you don't want to lose the client, but you got to tell who's your client and who's not. So even later you have to disabuse anybody from a misunderstanding about who your client is, even at the risk of them going to other counsel. You need to stay in your lane. Sorry, Mike, go ahead.
Well, no, and I mean, particularly at the risk of having them go get other counsel, because if they go get other counsel, you don't have to worry nearly as much. And you'd far rather, say to Abe, Beth, and Chris, I'm going to represent only Abe, and then have Beth and Chris say, well, we need lawyers, than to have, Beth and Chris sit there and think that you are their lawyer. And then later you're saying, oh, you're not my lawyer. I can settle this claim on behalf of one. And now I've got a mess where I could have just, upset people at the front end and frankly avoided a lot more headaches.
And what you're going to encounter is if they do go to other people, those other people are going to say, hey, the first guy woman knew what they were doing and they did a great job. Stay with them. You don't need me. You're wasting your money.
Exactly.
So it happens all the time. Just because they leave doesn't mean they're going to land anywhere.
No, absolutely. So then, the last thing, and this again gets back to the estate planning, is documenting your file. Make sure it's clear what the main purpose of the plan are. Have some sort of documentation of what the client rejected. One of the things, frankly, that I love to do is have things like checklists. Make sure, hey, we've talked now about these things. I finally have learned I have a folder on my computer called Standard Communications. And they are things that I send to people when something happens in their matter. In my world, we get offered an admonition by disciplinary counsel. I pull out my standard, I talk to the person about it, and I say, I'm going to send you an email that lists like 6 different things that you need to consider. And I do that in part to make sure that I always have those considered. As a lawyer, think about, are there checklists I should have where I'm going to share them with a client and say, did you think about charitable donations? Did you think about real property and how it's going to be distributed, or personal property? Are there other things you want handled in some way? And make sure that you've got documentation. And if a client's going to do something really unusual, explain why they're doing it. And then the mention again of the memo to the file may never reach the client, or may reach the client, only after everything's over. Far better to have a communication with the client rather than, memorize it. And people understand when you say to them, I'm going to send you a short email confirming what we just talked about and that you want this to happen. Far better to have that than to have uncertainty out there. And I see you just posted a list to the Checklist Manifesto, a great book and certainly something worth reading. But even if you don't read the book, just know that, if you have a checklist of things you need to get done in a day, or a checklist of things you need to get done with a client, those can really be helpful.
You know what I just read too? He wrote another book, Mike, about mortality and dying in America. And I'm getting older. I mean, I know you are. We've been friends
we
for
all
long
are.
enough that we.
Yeah.
So anyway, it's a fascinating book on dying. It's totally off topic, but he's a brilliant man, and I just read it. It's very interesting.
Good. And then you'll see here also, that question of continuation of the representation. What are the lawyer's duties after the plan is executed? Realize that, if something major happens, someone may be coming back and saying, we're going to use all those marketing communications and holiday cards and everything else you sent me to show that we still had an ongoing relationship. And you were happy to say, hey, I want your business, I want you to be your friend, but then you didn't tell me there was a major change of the law that is going to cause something to happen that I didn't want to have happen, or prevent what I wanted to happen to not happen. So, again, think that through and make sure that you're covered there as well. And then I always, if nothing else, I like to sort of pounce on people about money issues. And part of that is because this is an area of mass confusion and serious discipline for lawyers. So we'll run through a quick question here. Pat asks you to prepare an estate plan. You tell Pat you will charge hourly and you want a $1,500 in advance, and Pat pays the $1,500. My question for all of you is, where do you put the money? And there's a little bit of a trick here. And actually, I apologize because the heading says fixed fee, but actually, as you can see, that's hourly fee. The trick is that there is an exception for handling fixed fees, but it's only fixed fees. This $1,500, which is an advance on hourly billing, needs to go in your trust account. The exception doesn't apply there. And so, I always tell people this is your basic rule. And particularly if I were talking to criminal defense attorneys, I'd have to spend a lot more time on this. But the key, people misunderstand this. You're not allowed to treat a fee as earned until you've actually earned it. And so, if I say it's going to be $12,000 to handle your felony case, I can't transfer that $12,000 or deposit that $12,000 into my operating account until I've done enough work that I can reasonably say I've earned the full $12,000. Similarly, with an estate plan, if you say it's going to be $5,000 to do your estate plan, I can't treat that as my money until I've actually earned the $5,000. So in general, under Missouri rules and frankly under Kansas rules, and Illinois, by the way, is totally different. But under Missouri and Kansas, you have to, there's two, I was listening today to someone else's program. They said there are two types of fees. There's earned fees and there's unearned fees. And if it's an unearned fee, it needs to go into your trust account and be protected as laid out here. This is actually the version, and I apologize that I had that one wrong. You know, Pat asked you to prepare an estate plan. You tell Pat you will charge $1,500. Where do you put the money? This is where there is an exception in Rule 4-1.15C. And you can see there, a lawyer shall deposit in the client trust account legal fees and expenses that have been paid in advance to be withdrawn by the lawyer only as the fees are earned or the expenses incurred, except an advance flat fee, which does not exceed $2,000, is exempted from this requirement and may be deposited into another account. So if you are doing work for a client and you're doing it as a flat fee, you are allowed to put that flat fee in your operating account. However, if it is not an advance flat fee that does not exceed $2,000, this exception does not apply. So if you have a flat fee of $2,500, that is something that's going to need to go in the trust account, even if the client's paying you in $500 increments. It's the total amount of the flat fee that matters. Also, if it's an advance on hourly fees, again, it's going to need to go into the trust account. If it's an advance for expenses, it needs to go in the trust account. The only exception Missouri recognizes, and you can see this has been around for about 5 years, is that if you receive an advance payment on a flat fee and the total flat fee is $2,000 or less, you may put it into your operating account. And you can see here, again, I like to use pictures. If it's a $2,000 or less fixed or flat fee, then you can see the magenta dotted lines, and it's saying to you, okay, you can go ahead and you could put that money in your operating account. That does not mean it's non-refundable. If the client terminates you or if something else happens where the representation is not completed, you may need to return some of the fees, and do not use the word non-refundable in any sort of engagement agreement. It will bring the wrath of the disciplinary counsel's office on you. So there's a formal opinion that says don't do that. And my advice to you is don't do that as well. How long must funds be held? In general, under the rules, they need to be held for a reasonable period, which is assumed to be 10 days. This applies in all settings. It applies to someone who's advancing you fees, hourly, flat fee, whatever. It applies also to things like settlement payments. It applies to anything where you're getting money. And you could say, I bank at the same bank my client did. I know the money's there. Doesn't matter. You've got you need to make sure that you're going to have good funds, that the bank actually has the money. And again, you're supposed to wait 10 days. Now, there are circumstances where you don't have to wait the full 10 days, but you need to confirm not that the money's available or that the check has cleared the account, but actually that the money is in your account. And if you can't do that, you need to hold on and wait at approximately 10 days, a reasonable period. And again, the presumed period of 10 days before you go ahead and disperse those funds to yourself or to anyone else. Yeah. Just got a few minutes left, but I did prepare some scenarios. Gary, I think with your permission, I'll go ahead and dive into one or two of these.
Go. You got time, Mike.
Okay.
Then since I interrupted, I am going to re-put the code to get CLE credit. This is pre-approved in, I think, Missouri and Illinois. If anybody's in another state, we have we email us. We'll help you get it yourself and get that all good if you want to get credit in a state other than Missouri or Illinois. Sorry, Michael, go ahead, sir.
Oh, no. And I'm going to skip around these because I know I don't have tons and tons of time, but the first one it relates to a prospective client. Pat contacts you about preparing an estate plan. Pat meets with you for an hour and shares information about Pat's assets and desires. Pat then leaves and you never hear from Pat again. There's that question of, okay, what is Pat? Is Pat a client? Is Pat, someone who was not a client? We'll get to that in just a moment. But to finish off the scenario, you see there, Chris contacts you about challenging Pat's estate and asks, can you represent Chris? Can you tell Chris about your meetings with Pat? Now, a couple of things to mention here. Notice that there's no discussion about money changing hands. Money is an indicator of what's going on, but it's not required. You can represent someone without getting paid. You can represent someone and get paid. Instead, what we're going to be looking at, first of all, is, and I'm going to actually skip over Rule 4-1.19. Oh, I had 4-1.18 here. I don't. I apologize. I'm going to talk about a rule that actually is not covered here, but it's Rule 4-1.18. Under Rule 4-1.18, a person who comes and talks to a lawyer is treated as a prospective client.
18 for what?
4-1.18.
Okay. And then the model rule, ABA model rule 1.18.
Well, it's 1.18 is the model rule, but then in Missouri rules, it's all the Missouri rules start with a 4-. So
Yes.
it's 4-1.18A. And 4-1.18a says that when someone comes and speaks with you about a potential representation, they are a prospective client. And part B then says that if you receive any information from them, you need to protect that. So if we find that Pat was a prospective client, that Pat came to talk to you about engaging you possibly, that you then need to protect that information as you would have to protect for a former client. The next question is, can you take on a matter adverse to Pat? And there's actually 3 different answers here. The first is, if Pat did not provide you with any what we call disqualifying information, which would be confidential information that could be used to advantage Chris or to harm Pat, if you didn't get any of that information, you actually can take on the representation. If you did receive that information, but you reasonably limited what information you received, your firm can take on the representation, but you cannot. And if you received more information, or for example, you did not have limits in place as to your information, then your entire firm would not be able to take it. So we end up in a question of what sort of information did you receive? And of course, the tough reality is that the client's going to, or Pat's here going to say, I shared all sorts of important stuff with Mike. And meanwhile, I'm going to say as the lawyer, oh, Pat didn't tell me anything because I want to represent Chris. The most interesting case about this actually is a case called State ex rel. Thompson versus Duker. And in that particular case, the person met with a lawyer, the underlying court, the circuit court, found that there was a conflict because the lawyer actually had provided legal advice to the person, to this prospective client, and therefore they were a client. And because they were no longer being represented, they had become a former client. The appellate court got it and said, no, actually, we've got this rule 4-1.18, and applying rule 4-1.18, this was only a prospective client who never actually formed a representation. And therefore, based upon the information that had been provided, the law firm was able to be directly adverse to that client. So realize, again, it comes down to, what was discussed. And 2 things I will give as suggestions to sort of manage this. One of them is I like to take notes whenever I talk to prospective clients, and I usually type those notes so I'll have them long term. That certainly is one good way, to be able to memorialize it. The other thing that's nice is to actually create time entries. And we have a matter that's called, new client intake, that we just record anything where we end up not representing the person. And that's where we record those phone calls. But that way you're able to say, Judge, on June 27th, I had a 0.2 phone call with so-and-so, and here is what we discussed. And you can then indicate whether or not that's going to be a problem. So again, good things to have good records for, certainly very helpful. I'll mention this one. I'll probably do one more after this. Estate plan for another. Pat brings Chris to your office and asks you to prepare an estate plan for Chris. How do you deal with Chris? How do you deal with Pat? Does it matter who is paying for the work? This is a very common scenario. And again, it's often something where the lawyer is trying to be very helpful. So they say, sure, I'll help prepare Chris, Chris's estate plan. Often that estate plan has money going to Pat, and there's just so many headaches that come from this. The big thing I will mention there is you need to make sure that you have a conversation with Chris where Pat is not around, where you assess whether or not you think Chris is competent and whether or not you think that Pat is engaging any sort of undue influence on Chris. And really, you'd like to have Pat be part of this as little as reasonably possible. There's a doctrine called the I'm blanking on the word. There's actually recognition in Missouri Rule 4-1.14 in the Commons that you can have a family member present without necessarily waiving privilege. It may be appropriate to do it for purposes of the representation if, for example, Chris does need Pat to engage in things. But you want to be really careful about things. And the question of, does it matter who's paying for the work? The short answer is no, because there's actually, and I think this is probably my next slide, yes, that a lawyer shall not permit a person who recommends, employs, or pays for the lawyer's legal services to direct or regulate the lawyer's professional judgment in rendering such services. So realize, even if Pat is going to pay for the services, I need to make sure that I'm preparing the estate plan that Chris wants me to prepare, and I need to make sure that Chris's interests are protected in that estate plan. So, this is one of those areas of the law where you've got to be really careful. And I've seen some particularly nasty cases in Illinois where, the lawyer, again, thought they were doing the right thing. They thought they were really helping someone sometimes in dire straits. And when it blows up, one of the tough things to realize is that the disciplinary council in Illinois, the ARDC, is going to say your primary, in fact, in some ways, almost your sole purpose is that you need to be protecting the interests of your client. And when you took on the representation of that person, you needed to make sure you were protecting their interests. And Pat may not have those best interests in mind. So realize that if you're contacted by someone on a really short time frame, we need the documents prepared today, we need someone to run out and notarize this document today, or whatever it is, that's often a very dangerous situation. Don't let your client's problems become your problems. It may be a situation where you're willing to say, hey, I can't help you, I don't have the time. And realize that you're probably going to be the 10th lawyer to have said, I don't have the time. And if you're the 11th lawyer who takes on that matter, the fact that 10 lawyers turned it down before is a sign that, frankly, it was too dangerous to touch, and you shouldn't have been the one who ended up touching it. We talked very briefly about the marital plan and getting the waiver. You can see the rules there. I'll go ahead and end actually with this one, slide number 38, and the notice of an error. You realize that Pat's estate plan has an error. Do you need to notify Pat if Pat is still a client, Pat if Pat is a former client, or others if Pat has died? This actually gets into a very touchy area. The easy one, frankly, is going to be Pat if Pat is still a client. Now, let me throw the twist. What if Pat is still a client, but Pat may be incompetent now? Extra headaches and certainly time to talk to a risk management lawyer. But in general, you have an obligation to share material information with your clients. And so in general, you're going to have an obligation to notify them if there's some problem with their estate plan where you realize, for example, that a bequest is not going to operate properly or something like that. If Pat is a former client, again, we're looking to what sort of expectations were created there. There's some ethics opinions that say no. There's ethics opinions that may look at other factors. You'd really like to have some sort of engagement agreement that spells things out. Now, realize you may say, I want to reach out anyway and try to fix it because it's better to fix it ahead of time. That certainly could be the case, but here we're talking about what the duties are. The what about others if Pat has died gets into confidentiality. You actually may not be permitted to tell anyone because under Missouri rules, there are very limited instances when you're able to disclose information. Missouri does not, for example, have financial fraud exceptions or anything else. You're going to probably need some sort of authorization to take that information outside the attorney-client relationship. And so it may seem like, I want to do the right thing and I want to tell people. Well, for lawyers, often the right thing is not telling anyone because you need to protect that confidentiality. And I know with that, Gary, I said I would stop there, but if people do have any questions, feel free to reach out to me and I'll just scroll in and say thank you very much.
Thank you very much, Mike. And Mike, and I mentioned this before, but my experience with you is that, folks, Mike takes calls, he helps clients, he consults with people informally. If you do have ethics concern, it's like making that hardest phone call first. I would recommend getting counsel or someone sooner rather than later. I see Mike kind of laughing because what we don't want to do is we don't want to admit our mistakes, or we don't want to call our insurance company. We don't want to do these things. We hope it's going to go away if I hide my head under the blanket, but it doesn't. And frankly, that's sometimes why people get in ethics problems in the first instance. So I would just commend Mike to folks if they have ethics questions informally.
And Gary, a funny story for that, when I started heading down the path of professional ethics, I thought I would do ethics work for both lawyers and accountants. And I learned there's a fundamental difference between the typical lawyer and the typical accountant. If the typical accountant spots a potential problem, they will run from it. For too many lawyers, when we see problems, we double down. And that may be good for my practice, but it's often not good for the lawyer. So you're absolutely right. If you think you've got an issue, the best thing you can do is get some help. And I'm the sad type of lawyer who's probably dealt with judicial disqualifications 20 times. So it's certainly a chance. I've seen a lot of these things multiple times, and people will call me and say, I feel really bad. I had X happen to me. And I'm kind of like, oh, don't worry about it all. I had some other client that had X, Y, Z, and 3 other things happen. So there are those cases. I remember once I got a call from someone and I said to them, it's only Tuesday, but this will be the weirdest call I get this week. But that's not the normal circumstance. So.
And hopefully your week goes like that.
Yeah.
Weirder, but that's how the Murphy's Law means that you're going to get another call the next day, even crazier. Folks, so in the chats and the comments, I put the course ID for this program. The course ID in Missouri is 746566. I put it in the chat a bunch of times. All the materials are in the Google Drive that we provided to you. The contact information of Mike and Steve and Jill and Lee and John, our fantastic speakers today, is all in the both in the Google Drive and in the chat and everything. And at the end of the day, if you forget all this, when you're registering your CLE stuff, email me, Gary@burgerlaw.com, or my amazing assistant, Casey, Casey @burgerlaw.com. I put her email address in the comments for a bunch of stuff. We will help some of you, and some of you register if you need help or that kind of stuff. Email us, we'll get you materials, we'll get you help registered, anything like that. And again, I just wanted to thank, we're so blessed to be lawyers and to have this wonderful profession and to make good money. And one of the things that when the way we give back, and it's in my oath of office, my admission to Missouri and Illinois back here on my walls, is we have to help folks who can't afford lawyers. And that's what legal services does. I know I'm preaching to the choir because you all are here and you are our people and our community, and we appreciate you. But I guess what I'm saying is give money, give some money to legal services. Think about including legal services in your plan giving, as well as the plan giving for your other lawyer friends who are doing it. It's a way to give a legacy. It's something that helps keep our legal community tight and together, and to give us a legal community. So let's appreciate it and respect it. And that's all I have, folks. And you're going to get an email next year. This is our third one. We're going to keep going. There's 150 people, 126 right this second, between 150 and 300 every one of these CLEs. I wanted to thank all our amazing speakers again. You all are probably trying to go to lunch and are done listening to me, and I am done talking. Famous last words from a lawyer. But thanks again. Thanks for supporting this CLE. Thanks for our legal community. Thanks for our estate planning community. Thanks for our legal services community. Thanks. Bye.